unanimous in saying we think there's 4 issues we need to work on and make recommendations to the judiciary. The judiciary, having listened in carefully, either in person or by Zoom or both, has already started to implement some of these, which means for a bunch of non-lawyers, we didn't get it too bad up here. And we now have 2 final subcommittee reports that we will hear. You should have copies of them, and we'll talk about them, and I hope approve them. And then there's one final agenda item after that. So the subcommittee on guardian ad litem / parenting coordinator role, the chair of that is Representative Katab. Would you present your subcommittee's report, please?
Sure. Do you want me to read the report or just go over the highlights?
I'd say go over the highlights.
Okay. So this subcommittee was formed to look into guardian ad litems and also parenting coordinators. And we ended up mostly focusing on the parenting coordinator model. And House Bill 1263 was passed through the House. It's now in Senate Judiciary. It got introduced last Thursday, so it hasn't been voted on there yet. We felt like the parenting coordinator might offer a little bit of a kind of a way of looking at a way of dealing with this issue for now. And we've asked in the meantime, when it's a budget year, if the court could collect some data on GALs, which they were amenable to doing, mostly just collecting on, you know, when a GAL would have been used, but perhaps couldn't have been afforded. And similarly, if the parenting coordinator is passed, we'd also like to know how often it's used and then how often parties end up agreeing on something, just to kind of have a few data points. So I believe the court has 2 judges that hear many of these cases, and those 2 judges are gonna kind of track when they would have used a GAL, just to kind of, because there's really not a great way of tracking that piece, but I believe it's 2, is that right? 2, 3, okay, 3 judges. So that will be tracked, because that's kind of something that really needs to be looked at in a budget year, not in a non-budget year. So that was where we left off there, was we ended up with the HB 1263, and we will continue with looking into data next year kind of on our own. Happy to answer any questions if anybody on the committee had any.
Attorney Cregan, you want to respond to this? Give us a little update from the judiciary, please.
Good morning, Erin Cregan, General Counsel for the Judicial Branch. I think I have to start by thanking the committee so much for their interest in this topic and how deeply immersed you got into the work of the Family Division. I think you saw yourself personally many cases where litigants would have benefited from or appreciated the assistance of either guardians ad litem or other models. It is a little difficult to track how consistently we're not able to make appointments. And so we're going to work on that anecdotal sample, which will hopefully be helpful to you with our very large marital docket judges tracking it. And it will, out of the total number of cases they look at, that may give you an idea of how common it is. I personally did a fair amount of research looking through old budget codes with LBA, trying to find out how much this was funded at the past. It appears the code was reused for another fund. So the amounts that I saw in some of the old budgets, they're clearly the modern version of that fund and not the historical. So potentially larger than the actual past expenditures were.
Too bad this is being recorded, huh?
Well, I want to be transparent. I know how frustrating it is that we haven't been able to find this number. I went and had a big stack of paper files from one of our longtime judges that I was kind of rooting through, thinking for sure he had printed it out at one point. But I don't think we're able to figure out exactly how much the fund was before. It's certainly in the hundreds of thousands. So hopefully this anecdotal sample will be helpful to you, and just appreciate so much the committee's interest in this area.
Any questions for Attorney Cregan? Okay, good. Seeing none. Thank you. Anything further on this report. Could I have a motion to accept this report into our final report?
I so move.
Okay,
Seconded.
moved and seconded to receive the subcommittee on guardian ad litem / parenting coordinator role into the final report of this committee. And you've got, you can put on the face of that who moved and who seconded. Representative Smith moved, and I think Representative Ball
I did.
seconded.
I seconded.
Okay. And when you're ready, please call the roll.
Chairman Pearson,
Yes.
Vice Chairman Smith,
Yes.
Rep. Gregg, Rep. Ball,
Yes.
Rep. Kutab votes yes. Rep. Long,
Yes.
Rep. McMahon.
Yes.
Okay. Motion passes 7-0.
7-0. It is now in the final report. Next up, draft report from the subcommittee for consideration of the full membership of the Special Committee on Family Court on judicial training, education, supervision, accountability. And Vice Chair Smith, this is your group.
Thank you, Mr. Chairman. The subcommittee included Representatives Kutab, Lanza, Pearson, and myself. When we last met, I did submit the draft up until then of this subcommittee, and I will not go through all of that now because it's already in the record, but I'd like to bring it up to date. And I'm going to start after the text of the draft includes the Supreme Court Rule 45, continuing judicial education. And what follows is this. The thought that it would be timely for judges to receive essential training within 2 years of appointment, as specified in the Supreme Court rules, demonstrates to the committee that the Supreme Court does not take seriously the need for training before the judge is assigned cases. The committee understands that the courts do not play a role in appointing the judges. They can not specify requirements in terms of experience in lower courts or in particular subject matter jurisdictions. But once the appointment has been made by the governor and confirmed by the executive council, then everything else is in the court's hands. In conversations with court personnel, the subcommittee did develop a better understanding of the complexities of developing an inclusive and effective training program for the circuit court. There are 34 court locations with wide responsibilities, including civil, criminal, landlord, family, and probate. There currently is in place a 6-week basic training that involves initial orientation, ethics, mental health, ADA access, and similar issues. There are 2 weeks of family court training. That's 1/3 of the total training time, including parenting, guardianship, domestic violence, and stalking. There is also limited opportunity to observe experienced judges. Unlike the Superior and Supreme Court, circuit court judges have no clerks, and the entire court shares, as we understand it, 3 staff attorneys. The subcommittee did develop a whole series of questions on what is reasonable to expect for a system to be initiated, which judges should be required, what about the absence of support staff, how do you include in their decisions an explanation of why they reach their decision, would requiring mediation effectively reduce caseloads and therefore the time that any case is in the system, what specific staff should be added to the court with responsibilities to best manage in-house and external training. And then there's some other factors also about having a big brother or a big sister, in effect, an experienced judge paired with a judge with no experience. Is it possible to have a regular schedule of supervision? And might there be cases that could best be handled outside the judicial system in order to better meet the needs of the citizens and more completely again find a way to lessen to some degree the caseload that makes it almost impossible for thoughtful judges to have as much time as they need to make an informed decision. As we sit here today on April 2nd, House Bill 1005, which has to do with education and training of judges, has passed the House and is in the Finance Committee. By the end of the day today, it is highly possible that that bill will have passed out of the Finance Committee. At the moment, it has been combined with two other bills, one of them being a bail reform bill. And those of us sitting here would prefer that the bill be floating its own boat, but that's not the way Finance Committee sees it at the moment. The bill does, however, despite a good deal of pushback from some principals involved, the bill does provide the specific number of hours for training for judges and staff, and for the staff to plan and execute specific training requirements. It also has protected the word shall rather than may in order to help reinforce what I'm sure is the court's commitment to good training, but what I know is the legislature's commitment to appropriate training. This legislation, House Bill 1005, which will end up with a different number by the time it works its way through, would help make it possible for the courts to better carry out what the legislature considers to be essential in order for the circuit court created by the legislature to best meet the needs of New Hampshire citizens. Thank you, Mr. Chair.
Thank you for such a thorough report. Any questions for the subcommittee chair? Would you like to come up, Attorney Cregan, and interact?
Thank you, Mr. Chairman. Again, Erin Cregan, General Counsel of the Judicial Branch. One of the things that I have observed in the work of the committee, and I haven't even been in my position for all of it, is that the courts continue in the way that things are done, and there are some very, very good ideas that point out things that now that I reflect on them sometimes appear obvious. Representative Smith's suggestion of having more staff attorneys in the circuit court is an excellent suggestion. That is the life of a circuit court judge is a harried existence with very little of the support that one typically thinks of when one imagines a judge. I often think of them as firefighters. They just go and work And sometimes I talk to them and they tell me that they have had stress dreams about how many orders they need to get out, and ensuring that people do get timely justice. So I know that this is that's a very thoughtful and good suggestion. It's appeared in some of my fiscal notes now, where I say, well, maybe we could do more with a staff attorney here as opposed to requesting a full new judge. And I know that many people on this committee have been supportive of having more judges as well, and have had other really great ideas about staffing and doing things differently in the circuit court. Representative Ball, I think of your suggestion of working with the Department of Education, which was excellent. It was intuitive. It was just not something that we knew to even ask or pursue, and we are getting enrolled in that program now so that we can have more people coming from high school to work in the courts. So some of these suggestions have just, well, all of the suggestions are appreciated, but some of them are things we wouldn't think of ourselves. They're more creative, looking at other states, imagining different ways that things could be done, knowing how other parts of the government work from the different other committees that you're on or from your own past public service in other areas. So it's something that I've really appreciated, and I think that suggestion here is, I almost feel a little bit silly for not having thought of it, because when you say it, it makes so much sense. But we are used to persisting sometimes in the way that things have been done. I do appreciate, I just want to comment very briefly on the issue that that you mentioned, Rep. Smith, which is when I took this position, I read a few hundred pages of the relationship between the legislature and the judicial branch in the state of New Hampshire, which is a very interesting history. And I complimented Representative Lynn. I told him that he was, throughout that history, I had seen his influence in bar review articles and cases that he determined. And I would not want the judicial branch's position on the training issue to be taken as anything that impedes the respect that the judicial branch has for a recommendation or for an observation that comes from the legislature. That respect exists in a hearing, in a verbal communication of a suggestion, in a bill, in any form that it's received. I know that there is great comedy between the branches of government in New Hampshire. My most recent billet was working for the U.S. Senate Judiciary Committee. The relationship between the U.S. Senate Judiciary Committee and the U.S. Federal Judiciary is not this collegial, not characterized by this level of comedy and close work together. I don't say that to be negative on anyone there. It's just there's no history like the history that there is here for the collaboration between branches. So although that remains the position, it is not in any way a challenge to the power of the legislature, which is vast. The legislature can destroy courts, establish new judgeships, lower the maximum penalty for murder to a year, establish new civil actions, amongst many other things. The power of the legislature over the court system is almost unlimited. It has simply been our position that there is a very small zone, which is typically the inner administrative work of the judiciary, that is the independence of the judiciary, that training does come within in the same way that discipline came within in re petition of JCC when the Supreme Court adjudicated it a couple decades ago. So I know that this is a disagreement, and it's a respectful disagreement, and I hope that disagreement is taken in the spirit of great respect for the role of the legislature to make policy determinations, great respect for the work that you put into them and how good these suggestions are and how much they're appreciated, but a difference of opinion on a constitutional matter.
Before the special committee had its first meeting, I spent some time with Administrative Judge King and Supreme Chief McDonald, and it was like a first date where you're trying not to make a fool of yourself and trying to make a good impression, and you're inching, hopefully realistically, closer to each other. And what we all discovered is we wanted to gang up against problems, not each other, irrespective of what previous iterations of special committee on the courts may or may not have done. And it was that tone that continued. And so thank you for that commentary. In terms of outside eyes and your embarrassment at not seeing something, I bring in occasionally patients from the medical practice I'm part-time CEO of, because the people who work for me are so on top of what they're doing. They see that better than anyone, and they also miss things that people from a distance can see. So I intentionally bring in certain patients that I know to be articulate and savvy and say, please give a critique. And I interrupt them after 4 minutes of lavish praise saying, thank you very much, appreciate that. Now, how can we fix some things? Gang up with us. And they're helpful. And it's not because my staff isn't capable. It's they're in a silo and the other people have outside eyes, and that's all to the good. If the question on any particular issue where we apparently think you should do something and you're having some hesitancy, if it is a question of time or money or staff, those are issues that can be worked on together as the next budget's put together. Also, I am wondering about the initial training. If it should be different if a new judge was previously, let me use the British terms, a solicitor rather than a barrister. If you've got newly appointed judges who don't try cases in court, but are real estate attorneys and don't go to court, but do wonderful work, mightn't the training to be a judge be longer and more intensive than the training for a lawyer who has been in court regularly? Or what if in a different field? I have a friend in another state who is observing the circuit court for similar reasons, who tells me how a wonderful lawyer was just appointed to family court, and for 20 years he was very distinguished as a patent attorney, and I offer that I probably know more about family court than he does. So mightn't the initial training be more structured around different needs of incoming judges? Just a thought.
I think that's a very apt observation, and it does need to be changed depending on who is coming in. A former marital master is very knowledgeable. A former prosecutor is going to be great in district division, but is going to need more work for the family division. So that is something that we do try to do because we have been onboarding sort of 1, 2, 3 at a time. It has been a little bit easier to specifically structure the training to the needs of the individuals that are onboarding. I think we have 3 that we just went through a long training period with, and we were able to be a little bit different because their backgrounds were a little bit different. And so the fact that we're usually not taking on a large number all at one time has made that there are exceptions to that, but at least at this moment, they're sort of coming in 1, 2, 3 at a time. We get a little bit more of an opportunity to really gear our training to the particular individuals that are coming on board.
Take good notes, because our hope is this will continue the next 2 budget cycles. Vice Chair Smith, I think you wanted to make some comments.
I did want to thank you very much for your comments and how carefully attentive you are in terms of how you raise the issues that are of some concern. I do want to comment on one side comment that you made having to do with your experience in Washington. And I would suggest to you that over the 250 years or so, there have been many, many times, including recent times, where the legislative branch, both the House and the Senate, had very positive relationships with the Department of Justice and with the courts. And it is only sometimes in the history of this country that there has been where each of the branches lost sight of their common purposes. And I want to make sure that in New Hampshire, we don't lose sight of our common purposes without regard to the personalities of who at any specific time is operating in any specific position. So I thank you very much for the care in which you presented your comments.
Anyone else with a question or a comment? Representative McMahon.
Thank you, Mr. Chair. Attorney Cregan, to get your guidance relative to the current status and what is projected in the future, based on the report we have, with Court Rule 45 saying 2 years for additional training, are you in support of the bill that's in finance right now stating that the training would be completed within 3 months of hire?
Representative Kutab was kind enough to share the bill draft with me before introduction, and I did not recommend any changes to her proposed timelines, which I know she researched. I believe she reviewed other states' practices as well. So I do not, this is a recommendation from the legislature to the branch, and we receive it with respect, but we certainly have the ability to implement that. So it is not an inability to implement the legislature's recommendations in those areas. The major issues that we had that are recent relate to some sort of unusual events, including COVID, where actually we got a little bit of an opportunity to do more training because some of the cases were not able to be heard. It wasn't safe for folks to come in right away. So we sometimes might take an opportunity like that and go very, very heavy in 1 year, and you might say the next year it doesn't need to be quite as much because we utilized that past opportunity. So there are certainly things that happen that adjust what you might project in an average year and an average onboarding period. But, you know, barring unusual events, we do try to train people within that time period. And we have 3 circuit court judges going through that training. I think they just completed most of it relatively quickly after their confirmation. So I think that's something that we can implement. And I had the opportunity to consult on that bill and did not try to adjust the time periods that she recommended.
One follow-up, Mr. Chairman.
Follow-up.
Then relative to the bill that you have currently support on, but notwithstanding any adjustments to it, is the 3-month timeline enough to complete the total curriculum that's referenced in the bill in finance right now?
It is a continuing curriculum, so it is ongoing. There's a continuing education requirement in addition to the initial. It is not difficult to persuade judges to engage in training. These are people who voluntarily went to school for 20 years and would probably go back if they could. So the interest is there. Judges love to do training. I know that there has been a little caseload stress. And I think also the suggestion to have a judicial training coordinator is a good one. I previously worked in a department that had a dedicated workforce training director, and the training that she was able to procure and the work that she was able to do, persuading people to design new trainings, persuading people to do free trainings, going to experts and getting them to volunteer was excellent. It was the highest quality. So I do think that suggestion is a very good one that will lead to higher quality training. But we do have the ability to implement those continuing education requirements and the initial training requirements.
One last follow-up,
One
Mr.
more.
Chair. And specific to the report that we have before us, we're stating the circuit court judges do not have clerks. Is that not something we should be addressing as a legislature to reduce the workload that would allow this type of continuing training to be facilitated?
That's a great question and a great observation. I do think that has the potential to be a force multiplier for our judges. That being said, there are of course many demands at all times on the resources of the state, and we want to be mindful that we don't balance those competing concerns. The legislature does. They decide where the money will go for new hires and things of that nature. But would we use that? Would that make judges more effective? Would it potentially mean that someone who whose time is not as expensive as a judicial officer is able to displace some of the work that's currently being done by a judicial officer, I think ultimately there would probably be some savings there, and potentially we would not be as restricted as we are in the constitutionally, which we have to be, and how judges are chosen. They have to go through a process, but if we needed to, we could hire more. It's not the same lifetime commitment that choosing a judicial officer is, that has to be done more carefully and only based on what we know our needs will be for a long, long time. So I think that that's a very sharp observation and something that would make judges more effective.
Okay, thank you, Attorney Cregan. Thank you, Mr. Chairman.
Along that line, in the medical part of the healing center that I look after, we have doctors, nurse practitioners, and medical assistants. There was a week with a ultimate storm of things coming together where we had no nurse practitioners and no medical assistants. Doctors were putting patients into the room. Doctors were doing all the things, and the work slowed way down. And I'm thinking, law is not much different in terms of who's backstopping the ones on the bench. And if there are clerks and attorneys backing up the judges, it can get a lot more work done and with less expense than just naming more judges, although we need to do that too. So yeah, this is to be encouraged. This needs to be in the next plea at budget time, I think. Having been told on several occasions by more than one from the judiciary that as the report's recommendations are implemented and the judiciary welcomes our involvement, I wonder, how is it that we do connect with you on that? We don't wish to be presumptuous, but we do wish to take you up on that. And if something's being put together, for example, forms in the local court, with whom do we talk so we can say, here you are, pick me, I want to help? How do we do that?
Great question. I certainly will endeavor to connect, reach out to me anytime if you're trying to get a hold of someone in the judicial branch so that I can connect you with the right person. If there's something more specific to your question in terms of a particular project, please let me know, but I definitely try to be your single point of contact. I do sometimes disclaim that I put the general in general counsel, and I don't know as much as some others in the branch do on other topics. And I want to make sure that you speak to someone who is more knowledgeable than myself on some of these things, particularly if they're very technical. But I will get you connected with the right person.
So all of us here and anyone who is not here but is still interested in doing this, we'll let them know that on a topic of interest to us, we interface with you, and then you may refer us to the next person. That next person, having heard from you, expect a phone call.
Yes, sir.
Anyone else? Anything else on this report? Don't go away because we got one more item after this. If there is nothing further on this report, Chair will entertain a motion to accept this subcommittee report into the general report. I'll move. Representative Long and Representative Ball, any further discussion? The motion is to accept this report into the general report. When ready, the clerk, please call the roll.
Chairman Pearson.
Yes.
Vice Chair Smith.
Yes.
Rep. Gregg. Rep. Ball.
Yes.
Rep. Kutab, yes. Rep. Long.
Yes.
Rep. McMahon.
Yes.
Motion passes 7-0.
7-0. Now, the third and final topic we have is the speaker asked if once this was all put together and if you would be so kind as to give me what we already have, and I'll take this and I'll do some editing and rewriting and so on, and then get back to you. Okay. The speaker asked, would we now adjourn the committee? And I thought, what if something of a real hot button nature comes up over the summer? And we are now the ones who think, why didn't we see that? But here it is. Well, we've just adjourned, too late. 10 years from now, there's another special committee. Or, Mr. Speaker, we keep this open until end of October and perhaps decide this is a topic we want to address, name a subcommittee to, go to work on, then reconvene this, and that subcommittee report we discussed to see if it'll be in the final report. And he said, sure, keep it open. So we are open. And I've handed notes or sent email to various ones asking, what do you think might be a worthy topic for our consideration? Now, there's a number of topics that can be suggested that are very good, but I do not see they fall within the purview of the special committee. But there may be some which do. And this is from Representative Erica Leon, my former vice chair when I chaired Health and Human Services. She said, I have heard numerous complaints that unless there are broken bones, assault on a child in domestic situations is not addressed. In reviewing the statutes, district court has jurisdiction to arraign defendants charged with felony offenses and to hold a preliminary examination to determine whether probable cause exists to believe the offense was committed and the defendant committed the offense, and if so, to be bound over to the Superior Court for further proceedings. This is, she says, in RSA 490-F:3-A. And she adds, I would like to understand what currently happens when a child is physically or sexually assaulted. If there are already specific guidelines on how the reports are handled at DCYF, that would be helpful. Is there a likely intersection between DCYF and the courts on this? What might the special committee choose to do on this topic? And I'm not stipulating to any of the facts I've quoted. I've just read a report, and I want to throw this out to any member of the special committee and also to Attorney Cragen. Yes, Representative Katab.
I think it's definitely something worth looking into. I think on a similar note, we had also discussed potentially looking into domestic violence, but I think because they become hot topics, it becomes a quick point of contention where people are like, oh, let's not look into that. But it doesn't mean that it's any less important to look into. I think we have these issues going on, and I think it's important that we potentially do take some time to look into them. And I wonder if it could be a potentially like an intersection of looking into both abuse, but also the DV issue as well. Like if it could kind of be a combined issue to look into both of them, because I do think that is something that we continually heard issues on. And I feel like for DV, it was a similar situation where some judges were giving orders where people felt like they shouldn't have been given. But then on the extreme side, there was also some orders being given where, or some orders not being given where people were like, hey, this absolutely should have been given. I mean, think the Lindsay Smith case. And so it seems like there may be a similar issue with abuse where it's not kind of properly being addressed. And I wonder if this might be an issue that we could take a look at kind of together.
Might it be something that internally judiciary might wish to take a private look at, not necessarily disposing of what's before us, but at least beforehand, because it may be the case that as you examine how this has been handled, you may see there's a few judges that go way overboard on giving orders and a few judges that don't seem to do anything else. And if that is the case, that is continuing education individually. Some things can be and should be handled that way before they're handled more publicly, at least that much. Just a suggestion, an answer is not needed. What?
a special committee on DCYF, we also want to point out that criminal cases and civil cases are completely different and concurrent.
Right.
So the appellate court, when it comes to abuse and neglect, deals only with that purview outside of the criminal.
It's taking a look at it to see if then somebody else may pick up the ball. As long as that child is in family court, we're looking at that. If there's evidence otherwise, we are going to allow something else to happen.
Anything that happens in a criminal case, unless they're charged, cannot be admitted into a civil case.
Understood. Thank you.
Thank you, Mr. Chairman. One thing I will say on the work of the special committee on DCYF is that I understand, at least at this moment, that they're going to start, I think, with the investigative process that DCYF follows, and I think they're inviting the chiefs of police and some others. The court does have a role in the investigative process. It is a little more limited. By statute, on a probable cause finding, we can issue orders that, for example, allow an interview of a child. So there are laws that the legislature has passed that involve the court in some of those early steps. A very good kind of compendium of the court's role in abuse and neglect cases is our protocols, which are available online, and I'm happy to send a link to the researcher as well, that just lays out the existing law that we follow in investigative process in different types of cases. Certainly, the legislature can make adjustments in these areas, but I think the investigative, we have a little bit lower of a role, and I think that may be where the committee is starting, and then eventually they will go through, potentially at a later time, the court process as well with abuses and neglect cases.
Representative Leon, who gave me that piece I just read, is now the chair of the Special Committee on DCYF. And when the email was followed up with a phone call, it was on the order of the handoff from our perspective, family court. What more should we ask for, look at, whatever? Before then, it becomes a matter of Superior Court and different rules and different judges and so on. I think that's what she was looking for, is where is that connection from us to her?
And I think there's some connection in the abuse and neglect protocols between work that's done on our side and the court side, and then work that's done in the DCYF side, because they do have to interact with us for permission in a number of areas. And that's probably the best guide for anyone that wants to learn more about what we're currently required to do.
Representative Vice Chair Smith.
Thank you. I'm interested also in the difference between the civil component and the criminal component. And I myself would, speaking only for myself, would be fearful of anything that we might do that unintentionally blurs the separation between civil and criminal, particularly in terms of protecting the rights of those who may be considered. I'm picking my words carefully here, but because it's certainly, I don't want to say who are charged, because then we're off into a different game. And I'm not sure that this is the place to do that. And while I completely sympathize with Representative Leon wanting to find another little perch for some of the enormous responsibilities she has, I'm not sure this is the place.
I could not comment on that, ma'am. The legislature has set a lot of guidance to the courts already in terms of how to pursue an abuse and neglect case. The legislature can certainly adjust those standards. There are competing concerns. There are the rights of children. There are the rights of parents. The primary focus in a criminal case is on the rights of the defendant. The primary focus in a civil case is on the burden to the plaintiff in vindicating their rights. These are different frames. and not everything is always handled the same way by different states, but I think you do generally find that most states in abuse and neglect case, the primary consideration is the best interest of the child. And that's, it may be that all 50 states are identical in that standard. I'd have to do more research, but I think that is a relatively ubiquitous legal standard.
If it is the rights of the child for abuse and neglect, are we separating abuse and neglect versus physical sexual harm as two different spheres? One is civil, the other is criminal. Is that where the line is?
The standards are different. In an abuse and neglect case, the primary issue is what will happen to the child next? Where will they be? If you look at a criminal case, if the very high burden of proof is not met, then you default back to the situation which existed before the case was initiated. If a defendant is not convicted, then they move about their life as normal. In an abuse neglect case, I think that would leave a question about what happens next with the child, as opposed to what the disposition of the parent is. So abuse and neglect is focused on what is next and what is best for the child. A criminal case is either a very high standard is met, in which case potentially a very severe sanction is imposed, or it's not, in which case no sanction is imposed and no change to the status quo occurs.
Just to clarify my previous question, is that roughly the dividing line between civil and criminal court,
There are others for different case types, but I would say in this context, yes.
generally, for the liberal arts guy? Yeah, thank you. Yes, Representative.
Pearson. I just had a question. Thank you for answering and being here. Appreciate your time. One of the things that came forward in the testimony was that if people were found not guilty in a criminal court, the concern was that then when it came back to the family court, where you said that if they're found not guilty, they go on with their life. But in actuality, they don't, because then they go back to family court, who says, well, we don't really care what criminal court says, because this is what we think, so we're still not going to give you your children. And so it's not a double jeopardy, but you're still being penalized for something that you were found not guilty of. So that was the one. That was the one case, the one person who came to testify, and that's what he was saying.
So I appreciate that question, and that does happen, that the same set of facts will be the subject of both a criminal and a civil case, in which case the fact that the cases have different burdens, the very, very high reasonable doubt standard for criminal and the lower preponderance of the evidence, clear and convincing evidence standard for the civil case will result that the very high burden of the criminal case is not met, but the still greater than 50%, but not reasonable doubt standard is met in the civil case. So that does happen. I think it's not uncommon, for example, that a victim is not vindicated in a criminal case and then they sue the defendant and they do obtain a result in a civil case because the burden is lower. So that is not an unusual result. Double jeopardy explicitly bars a criminal sanction imposed by the same sovereign.
Right, and I understand that, but it almost is, even though you're going to a different, you're going to get the same result of losing your children. And I'm not saying I'm on either side of that. I'm just asking. I appreciate you explaining that, just to clarify.
That can happen, ma'am. It can be that someone is not convicted in a criminal case and yet they do face a civil sanction.
They have the same penalty regardless.
It should not be the same. It should not be, typically a civil sanction is not intended to be punitive. It's intended to vindicate the rights of the plaintiff or the focus of the case. So the plaintiff has lost money in a civil case and they sue to regain that money. It can be punitive if it's determined to be by statute. For example, punitive damages can be in a civil statute, but it's typically to vindicate the rights of another person as opposed to incapacitate or retribute against a criminal defendant.
Just for a quick follow-up. So just for clarification, so again, we're going back to that it's not supposed to be punitive and all of that, but denying the parent their child is punitive. So that's where I think we're having this real big, that gray area. That's where the struggle is, I think, in the family court and amongst the people who came to testify, as to how do we rectify that situation. And I think that's the real sticky part of this whole thing. And it may well require that we do more investigation into that area to find out how do we move forward to make sure that someone isn't denied their children unjustly.
That's a very tough balance. A lot of these laws, you're looking at different parties and their interests and how you balance their rights. And it's a very difficult job, and not every state has done it the exact same way. They are a little different from state to state. It's certainly a challenging question. I think you do often see that sometimes a state will try an approach, move back to a previous approach, because it's so difficult to get that balance exactly right. And I don't envy the task that you have.
Thank you very much.
We've got just a few minutes left in case there's anything additional. Representative Ball for something additional.
Thank you, Chairman Pearson. So the only thing I would bring up is another thing that we might want to talk about if we were to reconvene is after the bills go through that we have kind of sponsored to get forward, if they do not pass and they are not signed by the governor, that we may want to come back and look at why these bills may not have gone forward and what we can do to kind of go back to square one and see if there are any changes we need to make.
If anyone on the special committee has further ideas, please send them to me in an email. And if you want to flesh them out with some commentary and even make suggestions as to who might be interested in this subcommittee, in this committee and serving on a subcommittee, please do so. And we've got some time to do it. Excellent, excellent suggestion, Representative Ball. With that, I adjourn the meeting of the special committee and see you sometime. And thank you so much again for coming.
Mr. Chair, and speaking, I'm sure, for my colleagues, I would like to thank you for your leadership on this committee, which was not easy. And I think we've made some progress, albeit baby steps, but have made some progress. So thank you.
A leader is often as good as the people whom he or she works with, and thank you for being an excellent committee. All right, we will call up anybody on the Children and Family Law Committee who's out there in the gallery, and we'll take about a 3 or 4 minute rest and then Open the hearing on Senate Bill 566 relative to establishing a committee to study foster care families and the foster care system. Prime sponsor, Senator Chandler. And look at that. She knows the first rule of testifying before this committee. Turn the mic on. Thank you.
Thank you very much, and good morning, Mr. Chair, members of the committee. My name is Shannon Chandley, and I serve the people of Merrimack, Wilton, Milford, and Amherst in District 11 in the Senate. I come before you today to introduce Senate Bill 566. As the chair said, it is to establish a committee to study foster care families in the foster care system. So I have served several terms in the House, and I'm in my second term in the Senate. And throughout my tenure, I have received calls from constituents who have concerns about the foster care system. These concerns, sometimes people are quite desperate, and I'm sure you've heard some of the concerns that the folks have raised to me here in your committee. They include certainly a lack of placements for foster children, discrepancies between kin and non-kin fostering, requirements of the foster family and the living space. So this bill was a way of trying to look at the entire issue in one setting. For a while, I tried to come up with certain ways to maybe, how can we, and for lack of a better term, I'll use the word fix the system. But I think that it's not necessarily a system that is broken. It is a system that needs to be looked at, so problems identified, challenges identified, and solutions created. And I think that a study committee might be the best place to do that. I've reached out to various stakeholders, advocates, and members of the legislature who are expert in this area. And that certainly includes your chair and honorable members of this committee, and I widespread support for doing this. I considered that there have been foster care subcommittees in the Oversight Committee on DHHS, and there are other committees commissions and committees that look at children's services, but in consultation with a number of people with expertise in the area, it seemed like this might be the best way to move forward. The bill is very simple. It sets up your standard study committee, and I know many of us are loath to put forward more study committees where issues are extremely important. We need to do that. And the charge is to assess the regulations and requirements to qualify as a foster parent, the special circumstances of foster care provided by relatives, and how to best provide guidance to recruit and maintain potential foster families. It's not limited to that, and the committee, as it does its work, may find other areas where there are issues and identify those as needing solutions. So with that, I ask you to look favorably upon SB 566, and happy to take any questions if you have any. Thank you.
Before I turn them loose, I'm just noticing the all-star cast of House members you have as co-sponsors. Greg, Pearson, Petrino, Seidel. Wow.
It is. I said that I reached out to folks with a real, if not expertise, working knowledge of these issues, and certainly the members of this committee are those folks.
As my father often said, don't throw your shoulder out by excessively patting yourself on the back. Any questions for the senator? Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question. Fabulous bill. I just have one quick question. On line 8, it says the members of the committee shall receive mileage at the legislative rate. Is there a reason to not include federal rate? I'm just thinking of the accounting nightmare for the...
That's the same. It is not?
No, it's not.
So if that is something that needs to be addressed, absolutely not a problem to address it for the for the members of the committee who would be eligible for that rate. I think it's worth.
Does anyone know the difference?
So I know there's the state rate and the federal rate, but I did not. I assume both were encompassed in legislative rate, but that I am absolutely willing to change that to accommodate.
The federal rate is not included in your income tax on your 1040.
We can
That's-
elect, as I recall, the federal rate
Or
or the legislative
the
rate.
legislative rate
And-
becomes income.
I signed off saying I wanted the federal rate, and that is how I've been paid
did
for
I,
8
yes.
years.
And that's the reason I ask. I can't imagine that this person gets the federal rate for the rest of their legislative rates.
While we have the senator here, perhaps we could move past our own wallets and ask her any questions about the bill.
Otherwise, thank you.
You are welcome.
Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question.
Sure.
So this is only my first term in the House, and so I don't have a huge familiarity with study committees. So when a committee like this is formed, do you also investigate how other states potentially are doing foster care and if there's things that we can learn from them, or is it only kind of a review of our internal systems?
It would encompass both because it really is at the chair will, the committee will be established and the chair is able to run the committee as the chair sees fit. And I think that given, certainly within the parameters outlined in the bill, the chair may decide that the way to do this is to call in some of the people from the state and from the other agencies with whom the state contracts to understand what the situation is. There may also be people who have some concerns or complaints who want to come and raise those issues before the committee. And in terms of seeking solutions, looking at other states is one of the potential ways to find solutions.
Do you have a candidate from the Senate in mind who might like to chair this committee?
There are several able and willing folks, and I would certainly be happy to do so, but I'm defer to the Senate President's appointment.
You have good senators on this too. Anyone else? Representative McMahon.
Thank you, Mr. Chairman. Senator Chandler, just wanted to ask, to preface my question is, in optimizing the performance level of the committee to be appointed, the starting point being, has there been an audit done of the foster care system in the state of New Hampshire?
You know, I would think that would be something that would have to be looked into. I don't know how recently that has been done.
One follow-up, Mr. Chairman?
Follow up.
And then, because with the goal of getting this done while we're young, because this is a very important issue, would you be aware, though, of any highlights of subject matters that would be prevalent as issue 1 and 2 for the committee to address?
So I think issue 1 is and of course, again, this is subjective, but issue 1 may well be, how do we make sure that we have enough foster care parents available? And issue number 2 is, what do we do to train and guide them in their role as foster parents? And I guess I'll make that issue number 1. Those 2 things are issue number 1. And issue number 2 would be, what are the barriers? Why do people not serve, or why do they back away from serving?
So a fiscal no would be a reality in this work.
Any solutions that would be proposed through legislation would likely have a fiscal note, but I'm not sure of that.
Right. Thank you, Senator
are
Chandler.
welcome.
Thank you, Mr. Chairman.
What do you think, folks? Thumbs? Thumbs are unofficial votes. Oh, you are not in Massachusetts anymore, Representative. Only one thumb, please.
Thank you.
Thank you. Who'd like to move OTP on this.
Make a motion for OTP.
Okay, OTP by Representative Petrino, and I love to do bipartisan. Representative Nelson?
I second it, but I do have a question though, because would we
You
have
may
to?
have a question. It's been moved and seconded, so we may have questions.
Thank you, Mr. Chairman. Thank you to Representative DeSimone for catching that. Would we have to put through an amendment to get rid of that legislative rate wording, or?
This could be done by a floor amendment that
Yeah,
would be mutually
yeah,
waived off. Excuse me, could you call the roll and I'll speak and then I got to take a phone call.
Okay, we're gonna call the roll.
We're going to call the roll. Chair votes yes.
All right. The chairman votes yay. Representative Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford. Representative Bickford is not present. Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Melvin is not present. Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino will vote yes. Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Gibbons is not present. Representative Raymond,
Yes.
motion carries 13-0.
13-0.
Three not present.
Who would like to write the committee report?
Yeah,
Yeah,
will do.
thank you. And thank you, Senator. Thank you so much. Senator, before you leave, just we can be in touch. Often the speaker asks me for recommendations to committees for him to make the appointment. And if there is a particular House member that in your work you have identified as singularly qualified on this, I'd be interested in knowing that. Okay, and members of the committee, I've already got someone pass me a note interested. So if there's others, just let me know and we'll work on that. Thank you. Now open the hearing on Senate Bill 572 with Senator Bossy. Senator Ward, sorry. In for Senator Ward is Mr. Grant Bossy.
Thank you very much, Mr. Chairman and members of the committee. Senator Ward is a bit under the weather this morning. She asked me to pinch hit. We appreciate the courtesy. My name is Grant Bossy. I'm the Deputy Chief of Staff in the New Hampshire Senate, here to introduce Senate Bill 572 for Senator Ward, the prime sponsor. Mr. Chairman, the list of House co-sponsors on this bill is not as long as the last bill you heard, but it is quality. The Office of Child Advocate brought this
Thank you.
The Office of Child Advocate brought this issue to Senator Ward in the fall after conducting an in-depth investigation into incidents of severe child abuse where a number of infants were not adequately protected in the welfare system, due in part to the inability of DCYF, medical providers, and law enforcement to timely and effectively share information. That's why she introduced Senate Bill 572, a bill that establishes a commission to study the sharing of confidential records between law enforcement, the medical community, child protection services, and the legal community. This problem implicates a number of state and federal statutes, as well as policies and procedures across these three sectors. The commission will study the relevant laws, the barriers to information sharing in this arena of multidisciplinary teams to investigate child abuse, and how to prevent such roadblocks. Since many agencies are involved in the work, we need to safeguard the sharing of information so our children are protected while their privacy is also protected. I want to thank you, Senator Ward. Thanks you for your consideration and support of Senate Bill 572. I would defer questions to some of the advocates we have here, and if there's anything they can't answer, I can get your questions to Senator Ward and make sure you get an answer.
Any questions for Mr. Bossy? Representative Bickford.
Thank you, Mr. Chairman. Thank you for taking my question. So what we've got is a few entities that can't share information with each other, right? Like HIPAA is a problem for you, right?
Yeah, there are privacy concerns with both medical and law enforcement. They have their own standards, and getting through those silos so people can know when children are at risk is the challenge.
And HIPAA is a federal law, isn't it?
It is.
And so now what about the law enforcement one?
Well, there are various privacy concerns when you're dealing with an investigation. So state and federal laws, this is what the commission would do, is look at all the relevant laws that you need to comply with to see how can we share information without breaking either state or federal law.
The multidisciplinary.
Follow up?
Yeah, thank you, Mr. Chairman. The multidisciplinary thing is about professional people getting together that are involved in the child's issues, right?
Correct.
And they've been doing that for some years now. And so how have they worked in the past without this, with the problem of this federal law and police? Now, police are can't share like juvenile justice things, criminal, okay. And is there something else about police can't share?
Well, without getting in any specific cases that have happened in the past, Senator Ward saw specific instances where children were at risk and the right people weren't able to tell the other people what they knew so that they might be able to prevent a tragedy. This is what the purpose of the commission would be, is to find out where there might be gaps in the system.
Is there, follow up, are there any other entities besides those two entities that have a non-communication issue?
Well, I think you'll see, if you look at the text of the bill, there are a number of stakeholders that are included. And I think you've got the courts, you've got the Office of Child Advocate, DCYF, the House and the Senate, and law enforcement, hospital
They're not
association.
the friction points. I'm looking for the...
Yeah, I think that's something the commission would be involved in fleshing out and finding. I couldn't
Okay,
tell you
those
myself.
are the only two. Okay.
Yeah.
Thank you.
Anything further? Seeing nothing, thank you so much.
Thank you.
And if the senator could be in touch with me a little bit later on when the names of the committee will be put together, I appreciate that.
Thank you.
Thank you. Chair recognizes, I think I get it right, Amy Roy or Ross? Roy, okay, that's good.
Oh, there we go. Okay, good morning. My name is Dr. Amy Roy. I am a pediatric emergency medicine doctor with the Elliott Hospital, and then I also serve as a conductor of... Sorry. I also conduct specialized medical exams for the child protection programs, both with the Elliott and at Dartmouth. I've been in that role, I think, for about 7 or 8 years now, and certainly have encountered over that time lots of issues with sharing of information. As these multidisciplinary teams have sort of taken root in New Hampshire, I think we in the medical community certainly recognize them as really being an invaluable tool for child protection. These provide a really critical and a unique opportunity for dialogue between medical community, child protective services, between law enforcement, sometimes other stakeholders such as mental health, and may serve, when we are able to come together and have the kind of dialogue that we need to have, as an opportunity to really sort of solidify and crystallize in the sort of minds of those agencies that there is significant reason for concern for abuse and a real need to move forward expeditiously. Equally importantly, and I actually have a good example of this, sometimes what comes out of these multidisciplinary team meetings is an equally important opportunity to resolve a concern for abuse so that a family may really be able to put that episode behind them and to move forward. A recurring stumbling block, as we've already heard referenced here, is the capacity to share information. And certainly amongst the medical community, a pervasive concern is HIPAA, fear of a HIPAA violation, and the difficulty that most routine medical providers have in really understanding the nuances of HIPAA, which is a big, complex piece of federal legislation, and in knowing where there are, in fact, protections and opportunities to share information. Certainly, it's hard to believe that the intention of HIPAA is to prevent the sharing of information that is really germane to children's health, but we certainly need help in understanding how to communicate that, what the sort of guardrails are, and how to function effectively, but also legally within that multidisciplinary team setting. I think it's also important to remember, when we look at who is signing consents to release information, in many of these instances, a parent may also be a perpetrator, and that can be a little bit complicated. So I think I can say with real confidence that the medical community would urge and embrace the passing of this bill so that we can have some clarity that would allow us to make these teams the effective tool that we know that they can be. And I'm happy to take any questions if there are any.
Any questions? Representative Vice Chair Long.
Thank you, Mr. Chairman, and thank you for your testimony. The testimony that we get here often is medical, because if you have medical information at the school district, for example, that's not their medical information. It's your medical information. Now, my understanding medically is, I don't know, about 4 years ago or sooner, if the entity was under if they were held to the same confidentiality requirements, then it could be passed. Is that still the understanding?
I'm not sure I understand that completely.
Well, it was mostly on when we were looking at doing video medical appointments, but via video.
Okay.
The passing, we looked at the passing of information, so that the other entity wouldn't have to start from the beginning. And we found out that if they're beholden to confidentiality, then that information can be passed to them. Are you familiar with any changes of that sort?
No, I feel like I might not be the best person for this question.
All right,
But
that's fine.
I think, between there's sharing information between medical providers who are really operating under that same framework, then yes, that is allowed. And beyond that, I don't believe so, but I may not be the person to ask.
Okay, all right, thank you.
Any further questions? Seeing none, thank you so much.
Thank you.
Chair recognizes Lissa Mascio and Jennifer Jones from the Office of the Child Advocate.
Good morning, everyone. Lissa Mascio. I am the Associate Child Advocate, and with me is Jennifer Jones, one of our Assistant Child Advocates. I feel like I haven't seen you all for a while.
We've missed you too.
I've missed you. So we are here, as Senator Ward's representative said, this bill was born of an issue that the office discovered last spring-ish into the fall. As you know, we are an independent oversight agency overseeing all state serving agencies. And we support this bill, obviously, as we helped write it. We worked closely with Senators Carson and Senator Whitley and the Oversight Commission for Children's Services around this issue to increase protection for vulnerable children. And this piece of legislation is kind of central to that work in increasing communication around members of the multidisciplinary team. So I'm going to let Ms. Jones here talk about the process that this bill was born of a little bit and the specific players to answer some of the questions that have been asked.
Good morning. Lovely to be here with you all. I feel like I haven't seen this committee in some time myself, so it's nice to be back. So I want to talk a bit about kind of getting down to the technical pieces of what a multidisciplinary team does and why it's so important that a multidisciplinary team is able to collaborate. So when there is an investigation concerning child abuse and or neglect, particularly with reference to the investigation that Office of the Child Advocate conducted, as Lissa mentioned, last year, we took a look at approximately 9 cases where there were serious bodily injury to 11 non-ambulatory infants. So when you're looking at a case like that, there's always going to be law enforcement and DCYF, so your state's child protection collaboration. That's a co-investigation because we're not only looking at child safety, but we're looking at potential a criminal aspect. We know small infants can't injure themselves in the way that they were injured in these cases that we had our office had been referred to. So as we took a deep dive into the communication, so there were 2 aspects to it. We took a deep dive into reviewing the records for each of these individual cases, meaning we were looking at the communication between all members of the multidisciplinary team. So that includes law enforcement, child protection, prosecution. Excuse me, as Dr. Roy mentioned, sometimes that includes other entities like your non-investigative collaborative team members like crisis centers, mental health. And so we were looking at, again, the communication between those entities and how they were collaborating as an investigative team. And we also did a system mapping review so that we could look at human factors, right? Things that were barriers or things that may have occurred or happened just in day-to-day decision making of those investigators, as well as system barriers. So we largely found that in almost all of those cases, there was a breakdown in communication at some point in time. That could have been in the onset where law enforcement was responding and asking questions and getting information without the presence of DCYF, or quite the opposite, where CPS was out responding in the immediate and law enforcement hadn't been looped in just yet. And so those investigations, there's a lot of moving parts. So it's not just about the child or infant being seen in the immediate and the medical information that may come out of that one-time appointment or that one-time, referral to the ED, or, there's lab work, there's follow-up skeletal surveys that may uncover or identify additional injuries that didn't exist at the time of the first initial examination. And so what happens is, in the respective investigations, as that information continues to present itself, so as, you can imagine it takes some time for lab work to get back. It takes approximately 2 weeks for a skeletal survey to occur. If the investigative agencies are getting that information at different times and not able to share, it creates a real disadvantage about what one another knows about their investigation and how they're collaborating. And so we found it imperative to have this study commission to really get to some of, Representative Bickford had some great questions along with Representative Long about like, how does that work? How can you do that in a legally defensible way? And that's why we want this study commission. So what does it look like when there's medical issues, right? But they're specific to child abuse, and how do we pursue those investigations while honoring the privacy that all people are entitled to medically, but understanding that this isn't just calling up and inquiring about somebody's, average visit to their primary care physician. This is a child abuse investigation and safety is paramount. So what does that look like, and how can we navigate it in a way that we're really not running into one investigative agency having information the other doesn't. As you can imagine, a collaborative investigation requires good communication and timely communication. Another issue that we were able to elicit from our system mapping is that this also sort of in the long game, when these things go to trial, if DCYF and or law enforcement don't have the child's full medical record and they don't have all the records in their discovery, medical professionals can't speak to it at trial as expert witnesses. And that really, really can impede the judge's ability to assess safety in a way that they have all of the facts. And so there's it's a really multifaceted issue. And that's why we are fully in support of the study commission. Thank you so much for your time. I'm happy to answer any questions. Oh, sorry, did you have more?
You can either ask questions or I can tell you more, and then you can ask both of us questions. Up to you, sir.
I pick B.
Okay, I'll keep going. So, as Jen said, it is a very complex area. Rather than us just try and write a bill that would somehow cover HIPAA and law enforcement and DCYF, the study commission will help, because some of the specific barriers we were seeing is it does appear under the current laws, and I did attach you, I know we all like appendices, Appendix A, which is a compilation of all the relevant RSAs. It is clear from those read together that the legislature intends for these multidisciplinary teams to be able to communicate. However, unfortunately, there are some gaps. Some of these statutes require rulemaking, which just never occurred, so that's a gap. Some of them just sort of become circular in logic. So, for example, DCYF gets medical records and they get law enforcement records. However, they currently read their confidentiality statute to mean they can only disclose their records, i.e. things they created, their case notes. Not even to include the CAP exam that they paid for and sent the child to. So there's this like chicken and the egg problem that DCYF now has a lot of records and can't share it with anybody else. They can't give law enforcement the CAP exam. They can't tell medical what's happening. So that's a gap that needs to be solved. However, we didn't want to just sort of infringe a solution on them. We wanted the players to come to the table and say, how can we overcome that? Similarly, law enforcement, especially during an active investigation against a parent of one of these children, don't necessarily want to share notes about an active investigation, because if they give it to DCYF, because this is a court case, they're required to disclose it in discovery. So now you're actually giving records to the perpetrator. So it's a complicated issue. In that mapping, all of the parties said, we really want to fix this. We really want to be able to talk to each other, but these are all complicated issues. We need to sit down at a table and figure out what to do. That mapping did also discover another gap at the court, that some of the current laws around abuse and neglect, RSA 169C, the definitions, are being interpreted in a way to require a much higher standard than necessary. So we do have another bill I believe you're hearing soon when it comes over. SB 459 addresses that issue. So we're trying to kind of address the discrete issues and allow this multidisciplinary team, which the legislature created, but now has become a little bit bumpy in its execution.
Now you get to ask questions of either or both.
That's okay.
Vice Chairman Long.
Thank you, Mr. Chairman. Thank you for your testimony. I mean, this is probably going to put a stick in the wheel, but we hear several testimony of parents being left out of the loop. I understand there are some things you want to keep from them if they're the ones being investigated, but we're often hearing that even if the court or somebody deems that it wasn't at that level, they're still not hearing that, and the child is still either being kept from them, or so I'm wondering if that's, I mean, I get this information, confidentiality sharing, but also if parents could be, even a parent that's not being investigated for abuse, they're not getting the information. So they don't know what's happening with their child. They don't know what one entity or another entity, whether it's law enforcement, DCYF, whomever. So I think that would be, I think it would be helpful knowing where the gaps are and with the parents. We know what we want to keep from whomever is being investigated. I get that. But my understanding through testimony from parents is that they're not getting investigated. However, they still can't get any information about their child.
So this bill, thank you for the question, and I hear what you're saying because we've heard similar things. Frankly, parents call our office saying, "I can't figure out what's going on." This particular bill,
I send them to you.
Hey, feel free. This particular bill has to do with the professional multidisciplinary team, which is created under statute already. It is only professionals sharing information about an ongoing open child abuse case. Under some of the statutes, though, that I included in this appendix, though, RSA 170G8A is DCYF's confidentiality statute, which is very clear that a parent who is under investigation is allowed to get information about their case unless the department determines that disclosing to that parent, likely if they're a potential perpetrator, would the harm to the child would be outweighed. So that's within the statute. It's also within, again, sometimes there have been administrative rules that should be made that haven't been made or maybe are outdated. But parents receiving information, I think, would be a separate issue that a parent would need to deal with these separate entities. Law enforcement has rules around who's allowed to see an ongoing investigation, which is usually nobody. And then HIPAA, as Dr. Roy mentioned, it is actually usually the parent that holds all the control in a HIPAA situation as far as giving consent, which again, in this case, if the parent is the perpetrator, allowing them to refuse to disclose that child's medical records can actually really endanger that child. But parents getting information is actually part of some of these statutes and is separate from this particular multidisciplinary team just because of the way it was established in statute.
Right. Thank you.
Seeing no more cards on this bill, thank you for your testimony.
Chairman?
What? Oh, I'm sorry. Representative McMahon, sorry.
No, that's fine. You're multitasking as always, Mr. Chairman. Don't worry about it. I just have a question for,
See, it's moving up. I used to miss Representative Raymond, and I got that one solved, and, yeah, sorry.
cooperative collaboration to achieve consensus is now in place.
Okay.
Attorney, relative to the 170G8 confidentiality that you kindly provided, I want to ask your guidance on relative to the authority having jurisdiction. It appears to be the commissioner or designee on whether information, as it says here, if it outweighs the need for the disclosure, then they can deny that. Would you have recommendations on specific language that would need to be changed in existing law so it doesn't become a quantum physics calculation as to impact, but it is application versus interpretation of application of distribution of confidential information?
Thank you for your question. I think this study commission could potentially take up that question as part of the multidisciplinary team. I can tell you from when I was a DCYF attorney, so these aren't 91A requests, so they're not handled in quite the same way. These 170G8A information requests typically do go to the legal department within any district office. And then the discussion is held at that level of weighing those pros and cons of danger to that child for the disclosure versus the parent's right under the statute to get the records. It can go all the way up to field administrator level or, DCYF state office level. Typically the commissioner herself is not involved in those conversations, but it certainly could be part of a conversation around this statute. I think this multidisciplinary team, because the parent is not part of that professional team, that explicit question would not come up, but this statute's key as far as what information sharing means, who's assessing it, and at what level. So perhaps language could be offered. I think, I don't know of any personal cases where this has been an issue right now. It is meant to, the whole statute's meant to protect children. So it is weighed with the child's safety in mind.
One follow-up, Mr. Chair?
Follow up.
I'll stipulate to agreeing with you on protecting the children. That's not up for debate. The issue is the application of the protection for the children, as you both have correctly pointed out. If the commissioner is playing a major role in this, is there a representative? I was just looking at who's members of the committee. Is there a representative of the commissioner's office that then would, that should be, if not so designated, a part of this collaborative effort?
So the folks that are on this particular study commission are relating more specifically to that multidisciplinary team. So it is the director of DCYF who would sort of represent the field, and then a representative of the DCYF legal department, because it is the DCYF legal department that ultimately is making these interpretations of statutory release. So it is DCYF legal that has decided, even though this is our CAP exam that we have done, we can't show it to anybody else because that's how we're reading the statute. So I think probably, especially because DHHS is such a huge department, the commissioner's office is not really a person that's involved with this multidisciplinary team particularly, but it is DCYF legal as well as DCYF director who's ultimately kind of assessing those specific cases.
Okay, I'll leave it at that. Thank you, Attorney. Thank you, Mr. Chairman.
After a resolute search, I see no hands up. So thank you so much.
Thank you.
And this concludes the hearing on Senate Bill 572. Senator Ward and I had an extensive conversation about a few aspects of this bill. So you are now being handed an amendment. And yes, this is hot off the press. The amendment has been worked and reworked. And once you, can I have one, please? Sorry. May I have one? Excuse me. So once you get it, I suggest you put it side by side with the original bill, the bill as submitted. And I'll walk you through the changes we made. And for the OCA purposes, let me give you a sneak peek. For reasons I'll elaborate, everybody else on the commission now becomes consultants, and the only members of the renamed committee are 5 legislators. This is because of recently passed RSA 1449. But everybody who was not a legislator, who was in the commission, is also being mentioned by title as consultants because we want them there. And then there's a few other adjustments along the way. So this is not substantive to the task of this group. It is simply a matter of bringing the membership into compliance with an RSA. So if everybody has both, please look at the original bill, the first page, and line 26. Line 26 says, notwithstanding RSA 1449, the membership of the commission shall be. In other words, I know it's in law, but we're not going to do it that way. We're backing off that. And so if you look over at the amendment, page 1, line 11, the members of the committee, and it's named now a committee, not a commission, shall be, as before, 1 member of the Senate is appointed by the President of the Senate. Senator Ward suggests 4 members of the House appointed by the Speaker of the House of Representatives, one from this committee, one from Health and Human Services, Elderly Affairs Committee, and 2 members from any committee. We want to make sure we get the subject matter experts from the House appointed, as they will do in the Senate, at least one of whom shall be a member of the minority party. Now look at line 16. The committee shall seek testimony from various persons and agencies in order to accomplish its purpose. These shall include, but not limited to. That's the whole list of people, and the bill is submitted on the top of page 2. It's the same folks. We want them there, but the reason the LSR was made was large committees with quorum find sometimes they don't make their quorum. They have difficulties in steering a large ship. So we want them to come. If they want to come to every meeting, they're welcome to. If they only can come to certain meetings, that doesn't penalize the work of the committee. So that's the main change. But continuing on in the amendment, therefore, page 2 in the amendment, the original bill says this group will meet 10 times. And then it said the preliminary report will be November 1st. Good luck. And then it said the final report will be in 2025, which is after the election. So we saw some difficulties with that. And so the 10 meetings is out. They can meet as often as the 5 of them are willing to meet. And the final report is due in 2024. So that is the amendment Senator Ward and I came up with, which we think makes this a more wieldy committee. So I'll give you a minute to chew on that and ask me any questions.
Mr. Chairman, may
Yes. Yes.
Same question, page 2, line 21,
Of which bill? The bill or the amendment?
the amendment.
The amendment, page 2, line 21.
Same question since the other bill, the mileage, members of the committee should receive mileage at the legislative rate.
All I can say is I've been serving on committees and commissions for 8 years now here, and that's the language I've always seen, and I've never failed to be paid well.
Okay, thank you.
So we'll check that out, Representative, just to get an official answer on that.
Thank you.
Thank you. Anyone else? Vice Chairman Long.
Thank you, Mr. Chairman. So on line 21, the 10 meetings.
Of the original bill?
No, this is on the amendment.
There is no 10 meetings in the amendment.
Line 21?
Line 21 is about mileage. That's a previous amendment.
Also, this
The amendment in play is number 1397.
Oh, I don't have that.
Okay, that went passing by. If anybody's got an extra, there were 20 some odd of them.
I didn't take it because I thought I had it.
Okay,
Yeah, we have an extra right here, Mr. Chairman.
Oh, super. Thank you.
so that's removed. They can meet 10 times. It'll be up to them. Any further questions on the amendments? Yes, Representative Raymond.
Thank you, Mr. Chairman.
Right past Representative McMahon, yeah.
On page 2, line 25, it says the first meeting shall be held within 45 days of the effective date of this section. Is that 45 days from when the governor signs it? I
Yep.
feel like it should be obvious. And then I started questioning it and was like, oh,
Well,
maybe
yeah,
not.
you're in your first term. I figured that one out in my second term, so you're ahead.
Thank you,
That
sir.
does not mean informal but legal under 91A conversations may not be held. Individuals may not do research. Individuals may talk with the people who are coming to testify as experts. Just official meeting has to be held within 45 days. They can get to work now if they want to. Quietly, individually.
Individually. Okay.
Yeah.
It feels really tight. Thank you.
Well, there's a lot of bills with exactly this timing. Anything else? Are we ready to go on this? Thumbs? This one's pretty easy too. Thumbs, just one from, yeah, thank you. Then I open the executive session on Senate Bill 572, and I move Amendment 1397. Is there a second? On
I'll
the amend-
second.
On the, who's that? Raymond down the end, yes.
Oh, I'm sorry, I didn't see Ms. Perez.
Oh. All right,
I'll
sorry.
second.
Representative Perez. Now, any further discussion on the amendment? You see why it was done. The senators signed off on this. No committee of conference. We're not worried about that. This becomes the bill. Mr. Clerk, please call the roll.
Chairman Pearson,
Yes.
Vice Chairman Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Melvin, yes, Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino will vote yes, Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Raymond,
Yes.
15-0, with one absent.
And now the bill, as amended. I move ought to pass as amended. And Representative Gregg. Any further discussion? This is the bill now. The motion is ought to pass as amended by Amendment 1397. The bill is Senate Bill 572, moved by M. Pearson, seconded by Gregg. Would the clerk please call the roll?
Chairman Pearson,
Yes.
Vice Chairman Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Melvin,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino will vote yes, Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Raymond.
Yes.
Motion carries 15-0 with one absent.
Any objection to consent? Hearing none. This closes the exec session on Senate Bill 572, and I am reopening the exec session on Senate Bill 566. Any objection to consent? That was Senator Chandley's bill. It passed 13-0.
I have a question, Mr. Chairman.
Yes.
Can it be on consent if it needs an amendment for the legislative, or are we just going to leave it as it was with legislative mileage?
I think we can get a floor amendment if necessary.
Okay.
In which case it'll be pulled off consent. Yeah.
Oh, okay.
Okay.
Thank you for the clarification.
I'll take a voice vote on consent on Senate Bill 566. All in favor? Aye. Opposed? Thank you. Okay, and that closes the reopened exec session on 566. Now open the hearing on Senate Bill 359, raising the marriage age to 18, and we have Senator Altshuler to present. We do. Also an all-star cast of House co-sponsors, namely Long, Grossman, Levesque, Petrino. And if you look down at the bill and wonder why under committee it says judiciary, and you didn't know this is now the Judiciary Committee, the fact about that, it got to the right place.
Mr. Chair, are there copies? I don't have my actual copy of the bill, just all my supporting testimony. Shall I?
I don't know. My assistant committee researcher might know, and if not, There you go.
All right.
And we'll just hold off 1 second so everybody can pay close attention. Okay. I should have suggested after we've just looked at 572, if there's any members of this committee that would be interested in appointments. I have a ticket from one. If there's any others, just send me a note or let me know when I make recommendations to the speaker. I think we're good. Senator,
All
please.
set. Thank you, Mr. Chair and honorable committee members. My name is Deborah Altschuler. I represent Senate District 24, which includes the towns of Exeter, Greenland, Hampton, Hampton Falls, Northampton, Rye, and Stratham. I am honored to bring Senate Bill 359 to you with the wind of unanimous Judiciary Committee ought to pass recommendation and a consent vote in its sails. This proposal seeks to amend RSA 4574 and raise the age to enter into a marriage contract to 18 years old. As of July 2023, 10 states have banned underage marriages with no exceptions, requiring marriage license applicants to be a minimum of 18 years old. Delaware and New Jersey did it in 2018, Pennsylvania and Minnesota in 2020, Rhode Island and New York in 2021, Massachusetts in 2022, and Connecticut, Michigan, and Vermont in 2023. In New Hampshire, the average age a woman enters into marriage is 26.8, and for men, it is 29.3 years old. Nationally, according to the U.S. Census Bureau, the median age for marriage is approximately 28.6 years old for women and 30.5 years old for men. Children entering into marriage contracts is wildly out of our current cultural norms. In the back of your packet are two graphs showing the change in the entrance to the contract of marriage for American men and women. Between the years of 2000 and 2023, New Hampshire allowed 215 child marriages, 9 of them since the marriage age was just recently raised to 16. Child marriage is a tactic used by child traffickers to control victims. The Center for Disease Control and Prevention conducts the National Survey of Family Growth, which gathers information on pregnancy and births, marriage and cohabitation, infertility, the use of contraception, family life, and general reproductive health. The survey results are used by the U.S. Department of Health and Human Services and others to plan health services and health education programs and to do statistical studies of families' fertility and health. According to the NSFG, after 5 years of marriage, couples who married as teens have a 38% risk of divorce, and those who got married between the ages of 20 and 24 had a 27% risk. It drops down to 10% if you wait until 30 to 34 to get married. 80% of child marriages end in divorce. There is no data to support child marriage. Children entering into a marriage contract is just not a path to success. Senate Bill 359 empowers Granite State adults to enter into the contract of marriage as legal adults. Previous objections to this proposal included a wildly creative hypothetical of a 17-year-old service member shipping off to war and potentially leaving behind a pregnant girlfriend with no access to medical services. And while that makes for a heart-wrenching Hallmark movie, it has absolutely no basis in today's reality. 17-year-olds can only enlist with parental permission. The pregnancy exception is instead used as a way to avoid rape charges. A marriage license can indeed cover up sexual assault. the State Department labels marriage before the age of 18 as a human rights abuse. Just before New Hampshire finally took a modicum of action in raising the marriage age from 13 for girls and 14 for boys, a 13-year-old girl in Newmarket was married off to her abusive 17-year-old boyfriend, having been coerced by her parents. They are now divorced. Another objection is a comparison of our own personal and familial marriage experiences to today's norms. Social norms have changed. Americans are delaying or putting off altogether getting married for longer than before, according to data from the US Census Bureau. The median average age for men to first get married has risen to 30.2 years old in 2023, while for women, the figure is 28.4. Again, I refer you to the two graphs provided in your packet. These in the back. My parents dated and married young, very young. In fact, they married below the median and average ages. And they celebrated almost 52 years of marriage. They were married in 1968, 5 full years before the Equal Credit Opportunity Act of 1974. That act finally granted women the right to open their own banking and credit accounts, outlawing discrimination by sex in banking. Before that, women generally could not take out loans without a male cosigner, and lenders often saddled female borrowers with higher interest rates and larger down payment requirements. Marriage at that time was a financial best case scenario. The past 50 years have changed the landscape of financial opportunity for American women dramatically. We need to recognize the socialization of women and girls in the 1950s and 60s is so very different than today. I'm thrilled to be joined here today by advocates from the national organization dedicated to the eradication of child marriage in America, Unchained at Last. They will be providing the committee with more in-depth statistics and personal experience. As a visual, for a moment, think about the Hall of Representatives. Now fill that room halfway, and those are the children married off. Imagine facing each one of those kids trapped in a marriage contract they cannot exit and say, there just aren't enough of you to justify my doing anything to prevent this hall from filling up. Keep in mind, none of those children can gain sanctuary in a domestic violence shelter if they need it because they aren't old enough. I want to make it eminently clear that raising the age of marriage does not in any way, shape, or form pass judgment on anyone else's marriage origin story, my parents included. We can celebrate those who followed a teenage love affair into a decades-long marriage, while simultaneously acknowledging that marriage is more than a love story. It's a contract, too. A contract that should be entered into by consenting adults. We are the policymakers. We can make this right and set the legal age to enter into a marriage contract at 18. Contracts are for adults. Let's fix this in New Hampshire, and I urge the committee to recommend Senate Bill 359 as amended ought to pass. And I'm happy to take any questions.
Any questions for the senator? I don't have an amendment.
The bill itself was amended by the Senate at the top.
Where it says as amended by the Senate.
Yes,
Yeah,
that's what I meant.
that was a good giveaway.
Yeah. No more amendments. It's all done. Yes. Thank you.
Any questions for the senator? Seeing none, thank you so much.
All right. Thank you very much, Mr. Chair and honorable committee members.
And now, with all the pink cards, all in favor of the bill, most of the cards said time needed to speak 3 minutes. That will now be imposed on everyone speaking, and by 3 minutes, we mean 180 seconds. Chair recognizes Representative Timothy Horrigan from Stratford District 10 to come up for 3 minutes. Senator Altshuler, could you fill out a pink card? She did? You did? Okay. Okay, the clock starts now.
Thank you. So I'm Representative Timothy Horrigan from Stratford County District 10, which is just a town of Durham. So I was around in 2009 when we passed the marriage equality law, which actually to take advantage of same-sex marriage, both parties had to be 18. And I think that was part of a process of perhaps simplifying and clarifying our understanding what marriage is, which is it's first and foremost a contract between two people. And we used to think that one had to be male and one was female, and now it's commonplace for people of the same gender to marry. But that was something we recognized when we created same-gender marriage. It's something that should apply to what a male and a female are marrying. I mean, yes, people who married, their lives are connected in all sorts of ways, but there's lots of people who aren't married to each other who are raising children, lots of people married to each other who are living together, lots of people who aren't married to each other who are having sex, and that was true before 2009. It's even more true now. So I think having a uniform age of 18 to enter into the marriage contract is just basically the way to go. So that it's just not an equal, it's just not a valid relationship if either party, or perhaps in some case both, are not able to enter into a contract without parental permission. And of course, the divorce rate for people who marry, child marriages is very high. In some cases, the need to divorce happens even before the party is 18, and that creates a very major problem since they aren't able to initiate the divorce proceedings if they're under 18. So that's so I think this bill is simple common sense. It just clarifies what the evolution we've already seen in marriage law over the years. As I said, it's a contract between those two people, and there's lots of other stuff involved, but it's basically a commitment between those two people. So they should both be adults and able to freely enter into contract. And I don't know if the military thing is going to, apparently it's not going to come up during this hearing today, which is good, but it has come up on the floor in the past. And so the military, the military, your child is eligible for military benefits regardless of whether you're married to the other parent. The only issue is maybe you can't live on the base if you're not married.
10 seconds, Representative.
Yes, so the military thing, which may or may not come up during this debate, certainly apparently not during the hearing, is kind of nonsensical. And if you feel it's going to come up, you probably should have your researcher clarify it. Because
any questions for the representative?
Thanks.
Representative Panic.
Yeah.
My understanding is once a 16 or 17-year-old enters into a marital contract, that they are considered by the state an adult, and that they could go to see a lawyer and get the marriage nullified or go through a divorce, because once they enter into a marital contract, they're considered adults. So I think that's what my understanding was last year when this bill came forward.
Well, I would just say I'm not necessarily the right person to answer it. I'm not a lawyer. I've also actually never been legally married, but I have been in partnerships. So I would just say that's probably something we should have our excellent research team clarify, because I'm not sure if that's actually true. But even if you are sort of legally considered an adult, it's still more difficult if you're under 18, and then there's problems, after the divorce is granted too. So I would My first impression is I disagree with what you're saying, but that's probably an issue that we should have the researchers clarify if you think that's an issue before we exec the bill. And certainly it should be clarified before we have the floor debate, because I know a lot of side issues have come in and passed floor debates and derailed previous attempts to pass this legislation. So that's about all I have to say, although that was probably a fairly lengthy answer, but thank you.
Any further questions for the representative? Seeing none, thank you
Thanks.
so much. And Representative Cassandra Levesque. Flown it at great expense. And you've got 3 minutes as well.
Thank you, Mr. Chairman and members of the committee. My name is Cassandra Levesque. I represent Stratford 4, which is Stratford and Barrington. In the past few years, there have been increased attention both globally and nationally about the need to end child marriage. In the United States, bills have been introduced in many states in an attempt to end child marriage. Since 2016, at least 25 states have straightened their marriage age laws, but it is not enough. We should be stepping up and fully protecting them from this human rights abuse. You may ask, how is child marriage a violation of child's rights? Children have the right to education, to live their life free from violence. Children have the right to the best health care possible, the right to a clean and safe place to live and develop in the best way possible, and they have the right to information on how to be safe and healthy. Survivors and those that help these children will and have testified in multiple venues that these rights are violated when the children enter marriages with adults. The U.S. government has acknowledged that child marriage is a human rights abuse. Abolishing child marriage is a part of a larger global strategy to promote gender equality and reduce poverty. According to the U.S. Global Strategy to Empower Adolescent Girls, child early and forced marriage arises from and often perpetuates gender inequality. It is a human rights abuse that contributes to the economic hardships and leads to underinvestment in girls' education and healthcare needs. Child early and forced marriage undermines economic productivity, threatens sustainable growth and development, and fosters conditions that enable or exacerbate violence and insecurity, including domestic violence. It produces devastating repercussions for a girl's life, effectively ending her childhood. Early marriage forces a girl into adulthood and motherhood before she is physically and mentally mature, and before she completes her education, limiting her future options, depriving her of the chance to reach her full potential, and preventing her from contributing fully to her family and community. Let me further state that when you open the door for child marriage, it is not only a child in child marriage we are allowing. We are allowing adults to marry children. We are allowing this venue for human trafficking. We are allowing the coercion of children. There is more at stake than teenage romance and high school sweethearts marrying. Child brides face serious consequences. Girls who marry at 18 or younger are at 23% higher risk of heart attacks.
You have 15 seconds left to wrap it up.
Okay. And heart attacks, strokes, and diabetes and cancer. I've been fighting this since I was 15 years old. That is 1 year younger than my great-grandmothers and my grandmother when they were married at 16.
Thank you, Representative. Will you take some questions from your colleagues?
Absolutely.
Questions from your colleagues. Representative Panic.
Do you know how many child marriages happened in New Hampshire in the past year or two?
I used to. I haven't gotten the full update, but I'm sure.
Somebody
that
will be bringing that forward.
It's 0, and the year before I think there was 2.
No. Somebody with the answers will be bringing them forth, so let us not speculate. Any other questions? Representative Perez.
Thank you, Mr. Chairman. Thank you for taking my question. You know that I'm being very vocal about this issue, and then I always support anything that has to do with child marriage. But my question to you is on line 2 and 3, no person below the age of 18 should be capable of contracting or valid marriage a marriage contract as such a person should be null or void. This is my only concern. And I know that I'm a survivor, that I was married when I was younger, but my concern is that we have people coming from other countries, that we have different points of view. And by null or voiding something, I'm just concerned that not every single marriage ended into abuse relationship or not work. That's the only concern that I do have.
So that would fall under where state to state type thing, where we do recognize that. And if you get married like out of state where they allow it, or out of the country where they do allow that, then we have to fall under federal jurisdiction, I believe.
That's the full faith and credit clause of the Constitution. So they wouldn't suddenly be unmarried when they moved to New Hampshire.
Thank you.
Representative Petrino.
Thank you, Mr. Chairman, and thank you for taking my question. Would you agree that the number of marriages that take place in New Hampshire, child marriages in New Hampshire, is irrelevant if you believe that child marriage is wrong?
Yes, I do believe that.
Yeah, good point. Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. And I know you have very good intentions in protecting young women. My question kind of stemmed from some of the testimony from the representative before you. We have a problem with teenage girls cohabiting with older men and with their teenage boyfriends' parents, living with them. Are you aware of a young woman at the age of 16 or 17 or 15 who is in that situation? Would they be able to go to a domestic abuse shelter? Because they're underage?
I believe anybody under the age of 18 will be turned away from all domestic abuse shelters because they do not have a legal guardian with them. And most of those that, if someone is trying to get away from their spouse or whoever, then in these instances of child marriages, there are many victims who have gone to domestic violence shelters and who have been turned away, or the police have been escorting them back to their parents or their legal guardian, who happens to be their husband, who then further abuses them even more because they try to get away from them.
Follow up.
Yeah, I think probably that my question isn't really germane to your bill or amendment, but maybe we can work on something like that in the future together if we're reelected.
Yeah.
Thank you.
Any further questions for the representative? Seeing none, come on back.
Okay, and I do have flash drives for anybody that wants data on child marriage. Yep.
Do they come with instructions for old people?
I can show you how to use
Thank you. Just want to give chance to the Office of Child Advocate. If you have any information to that question about turnaways, you want to come up and answer that question? You don't have to. Okay, they wave off. They look embarrassed. I'm sorry. I should have texted you. Okay. All right, the chair recognizes Emma Savini from New Futures. You asked for 2 minutes. I'm going to hold you to 3.
Thank you for the extra minute. Good afternoon. Oh, it's still morning, 5 minutes. Good morning. My name is Emma Savini. I'm the Children's Behavioral Health Policy Coordinator at New Futures. New Futures is a nonpartisan, nonprofit organization that solves problems through policy change. We are here in strong support of Senate Bill 359 because it reduces adverse childhood experiences, or ACEs, which have been long linked to serious long-term health effects, not just in childhood, but throughout adulthood as well. When children are engaged in a marriage contract before they reach the age of majority, typically these stories are accompanied by severe trauma, sexual emotional, physical abuse. All of these highly traumatic events contribute to lifelong consequences such as you've heard, heart disease, mental health concerns, substance use disorder. Children who have experienced 4 or more ACEs have higher rates of being trafficked. Something as simple as back pain. All of these things can be mitigated by having protective factors in place, having supportive adults outside of their homes, having access to services. This bill is a really important and critical step in establishing one of those protective factors, protecting our young kids from entering into a contract and having these traumatic experiences. I'll also note that this is part of a national movement. There have been 11 states, soon to be 12 states, that have enacted legislation similar to this to end child marriage in their states. Additionally, to answer Rep. Panic's question, there have been 215 minors married since 2000, between 2000 and 2023. Since 2019, there have been 9 children who have been married. 83% of these were girls wed to adult men, with an average age difference of 4 years older from the child who was married. And the 2018 legislation was certainly well intended, but only protected about 4% of the individuals that it needed to protect. The rest of those cases are aged 17 and above. Every single life is important. Even one child marriage is too many. We have done as a state so much to invest in our system of care and invest in the mental well-being of our children. I think this is a critical next step in ensuring that we mitigate ACEs as much as possible. Happy to answer any questions to the best of my ability.
You have 10 seconds in the bank for next time you come.
Thank you.
Any questions? Representative Panic, you're on a roll today.
Yes, I am. Thank you, Chairman. Out of those marriages that occurred, do you have the statistics on how many ended up in divorce?
I don't have those statistics off the top of my head. Sorry.
All right, thank you.
Seeing nothing further, thank you so much.
Thank you so much.
Chair recognizes Lynn Currier Stanley from the National Association of Social Workers, New Hampshire chapter. And thank you for the good handwriting.
Well, thank you for recognizing my good handwriting. Good afternoon, members of the committee. For the record, my name is Lynn Currier Stanley. I'm a social worker. I am the executive director of the National Association of Social Workers New Hampshire chapter, and I live in Pennacook. Social workers have a number of concerns about child marriage. This is not a maturity issue. This is a legal rights and responsibilities issue. 30, 40, 50-year-olds may not be mature enough to get married. It is about the legal rights and responsibilities that you obtain once you turn 18. We are concerned about parents prematurely relinquishing their parental rights and handing it over to another, an 18-year-old, a 45-year-old, making them technically their legal guardian. We are concerned about how child marriage is used as a tool of child traffickers. Somebody taking a 16-year-old across state lines for nefarious purposes is committing a felony. Somebody taking their wife across state lines is just going to Vermont. We are also concerned about, of course, about the mental health impacts that child marriage can have. We are concerned for those children. We are concerned for the adults that they become. We're concerned for the social workers who have to help those often young women put the pieces back together. Yes, it is small numbers, but it may not be meaningful to many, but it is absolutely meaningful to those who it affects. Thank you very much, and I'm happy to answer any questions that you might have. Thank you.
Seeing none, thank you for your testimony, handwriting, in a minute and 10 seconds. to your credit account. Becca Powell from Unchained at Last, and that intrigued me earlier when I heard that term.
Good afternoon. My name is Becca Powell, and I'm here representing Unchained at Last, the survivor-led nonprofit that's dedicated to ending forced and child marriage in the United States. The 2018 legislation that raised the marriage age to 16 was very well-intentioned, but it didn't go far enough. 96% of the minors who married in New Hampshire before 2018 were age 16 or 17. So the 2018 legislation only protected 4% of the individuals it was intended to protect. But SB 359 isn't about creating a better system to enter minors into marriage. This bill will do what 11 other U.S. states have done and set the marriage age at 18, no exceptions. Because child marriage itself is inherently dangerous, as you heard. This has nothing to do with maturity. Minors don't automatically wake up on their 18th birthday with some newfound wisdom or ability to make good decisions. What they do wake up with is all of the rights of adulthood they didn't have even the day before. And that's so crucial, especially for a minor who's being forced to marry. Before a minor turns 18, they can't even open the door and leave home to get away if their parents are planning an unwanted wedding for them. Minors who run away from home are repeatedly can be deemed a child in need of services and summoned to a court hearing to determine further disciplinary action. In our experience, domestic violence shelters across the U.S. will routinely turn away unaccompanied minors, and youth shelters in general are not a solution. They typically only limit the stay to 21 days, and their main goal is to reunite that minor with their parents. Additionally, a minor can't easily retain an attorney because contracts with minors are voidable, and they generally can't file a legal action, which just creates additional obstacles for them. And Representative Panek, I want to address a question you asked earlier. Yes, minors are automatically emancipated upon marriage, which does bring some limited legal rights of adulthood. However, these rights do arrive too late to prevent a forced marriage. That minor would first have to undergo the trauma of a forced marriage, which in our experience can typically mean being pulled out of school, raped on her wedding night, and forced into a life of domestic and sexual servitude. And you can't undo this trauma, and you can't unrape a minor just by giving them some limited rights of adulthood by emancipating them afterwards. Also, the rights of emancipated minors are, as I said, limited. In our experience, domestic violence shelters will turn away even emancipated minors. And emancipated minors often have trouble accessing the rights that they do have. Imagine, for example, how a landlord would feel about renting an apartment to a 16 or 17-year-old. And because of these limitations, globally, all child marriage is recognized as being forced marriage, because minors just simply do not have all of the rights of adulthood they need to enter any contract, let alone a contract as serious as marriage. And because of this, when girls have reached out to Unchained, who provides direct services to those who are facing forced marriages, when girls under 18 have reached out and asked for our help and have learned of their limited legal options, we've unfortunately seen some turn to self-harm and even suicide attempts. So for all those reasons, I ask you to please do what the Senate did and vote yes on SB 359, and I'm happy to answer any questions.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. Are you familiar with our present law here in New Hampshire?
Yes, 16 and 17-year-olds can enter into marriage with the consent of one parent and judicial review.
Follow up.
Because I do think that they do have certain legal rights under that law.
So as I said, yes, when they're married, they're automatically emancipated and they do get some limited rights of adulthood. But as I mentioned, those rights arrive too late to prevent a forced marriage. And, that trauma, unfortunately, can't be undone just by giving them some of those limited rights of adulthood. And additionally, as I mentioned, those rights are only limited. And in our experience, domestic violence shelters will turn away even emancipated minors.
Thank you for your testimony.
Thank you so much.
Chair recognizes Michelle, is it Hanish? From the AHA Foundation. Well, that's what it says.
Well, I'm glad you could read my handwriting, because I'm sure it was
Not only that, I'm intrigued. Tell me what AHA Foundation is.
Sure. AHA Foundation is a nonprofit.
No, tell me what it means.
Oh, it's our founder's name. Excuse me. Ayaan Hirsi Ali. She was a survivor of forced marriage and female genital mutilation.
AHA.
So
3 minutes.
Thank you. I am Michelle Hanash. I am the Director of Policy and Women's Programs at the AHA Foundation. We are a nonprofit working to end harmful practices like child marriage. We also receive those help requests from individuals fleeing forced marriages across the U.S., including from minors. And it is because of these heartbreaking stories that we are so adamantly in support of SB 359 and keeping the marriage age at 18 and eliminating the dangerous loopholes that allow for children to be entered into marriage. And I believe in the past it had been asked whether it would be a good idea to add a military exception to the marriage age. That's not currently the law, and that's not proposed in SB 359, but I'd like to take just a few minutes to explain why that would not be a good idea. So first, to explain the common misconception, you do not need to be married to list the mother of your baby or anyone for that matter as the beneficiary of your death benefits. And as you heard, children receive service members' benefits regardless of their marital status, and using other spousal benefits that would not apply, like health insurance or housing, to a non-married partner are not a reason to keep children entered into child marriage. Using someone's current financial dependency as a justification for child marriage will only keep them further dependent and reliant on public assistance, government aid for a lifetime. We all believe that there are other solutions than entering children into contractual sexual relationships in order to receive housing or health care. We would say Medicaid, not marriage. And sadly, people sitting here today testifying in support of this bill have had to help children who are being forced to marry service members. And those children receive protection as much as any child being forced to marry a civilian. And you should know military exceptions are not the norm. Only one state, Alaska, has a military exception. We couldn't find any country, even in a war-torn area like Afghanistan, that actually has a service member exception. We have support from service member advocacy groups who are saying, don't support child marriage in our name. A letter of support was submitted by Protect Our Defenders saying just this: we urge you to listen to them and not cling to child marriage, a harmful practice that prevents girls from having liberty, economic freedom, educational opportunities. We urge you to pass this legislation as soon as possible. Thank you so much.
Any questions? Aha. Representative
I might as
Bannock.
well just get everybody upset with me.
We're not upset with you.
Well, after I say this,
We'll
you
eat our
might
lunch
be.
quickly.
But
Go
thank
ahead.
you, Mr. Chairman. My confusion here is we're advocating for genital reassignment surgeries for children under 18 years old, but you're not going to allow them to be married under 18 years old. I can't seem to line those two different thought processes up. I think something like this needs to be left alone.
It has to be a question, Representative.
I mean, how do you justify that part and then this part here where you're saying you can't get married? We'll reassign genital surgeries, but we won't allow you to get married. It just, how do you square that away?
Sure. Thank you for the question. As people have mentioned, marriage is a contractual relationship. 18 is the age to enter into contracts. Setting the marriage age at 18, I should say keeping the marriage age at 18 and eliminating the loopholes is entirely consistent with the laws when it comes to entering into a contract. And we shouldn't allow children to be abused because of other issues that are being debated when it comes to legislation. Ending child marriage is entirely consistent with the laws on childhood and on contracts, and otherwise having loopholes in the law completely makes a mockery of so many other laws when it comes to children.
Thank you.
Any further questions? Thank you for your testimony.
Thank you so much.
Chair recognizes Mr. Dana Albrecht. And you also have 3 minutes.
Good morning, Mr. Chair. Thank you. Just to address a few things I heard earlier, to begin with a brief anecdote. I once found myself outside an abortion clinic speaking to a young African-American gentleman, very upset that his European girlfriend was not going to allow him to be a father. And so it seems...
This is off topic. Please speak to the bill.
A brief anecdote to frame the bill, please.
All right.
So the first choice, it seems, is death, and I'm speaking to Rep. Perez's comment. And after facing death, we face birth. And then, directly to Rep. Perez's comment, the next choice we face is gender assignment and whether we think we ought to be a boy or a girl at a very young age. After that, we face the choice of who we find attractive. After that, we face the choice of whether to consummate that. After that, it seems today's reality is we decide whether that ought to be a marriage. After that, a divorce, and eventually death. And I find this a curious order of events. And if you go to the most recent Supreme Court case, Obergefell at 2590, it says the U.S. Supreme Court says a third basis for protecting the right to marry is that it safeguards children and families, and thus draws meaning from related rights of childbearing, procreation, and education, going back to Pierce v. Society of Sisters, protecting religious minorities. So while many view marriage as a legal contract, if you look at line 15 here, it says no magistrate or minister of religion shall solemnize any marriage. I submit there are many who view it not as a legal contract, but a religious sacrament. And I'm not sure how this bill is written doesn't run afoul of Obergefell, both in terms of due process, recognizing full faith and credit, and recognizing First Amendment rights. And granted, it may be a very tiny minority, but I would just urge you to consider this in the broader context of all of these issues and at what ages all of these sort of events ought to occur. Thank you.
Any questions? Seeing none, thank you for your testimony. I do know that in most states, the minister of religion is both a minister of the sacrament and a legal representative of the state. And I do know that in those states where sometimes those are in conflict, that is a discussion. Can the minister solemnize matrimony for the church and not be a representative of the state when those two things clash? I'll just leave that as an open issue. Okay.
Thank you. These are just things I'm hoping you'll consider as you.
Finally, the chair recognizes Freddie Rice from Unchained at Last, and you two have 3 minutes.
From Brooklyn, I can talk very quickly. I'm Frady Reese. I am here as from Unchained at Last, and I'm a forced marriage survivor, so this is very personal for me. I'm also an advocate through Unchained at Last. We work with survivors who are escaping forced marriage, and I'm an expert on this issue. My research and writing have been published extensively. I want to talk about how the current law in Massachusetts, here in New Hampshire, allowing 16 and 17-year-olds to be entered into marriage actually encourages, legalizes, and incentivizes the trafficking of minors under the guise of marriage. The way it works is the federal government does not specify any minimum age for marriage. And this is a really dangerous and gaping and shameful loophole in federal law that allows and encourages the trafficking of minors in the U.S., and mostly it's girls who are trafficked for the U.S. citizenship, forced to marry adult men overseas who get a visa and a path to citizenship. It also encourages and legalizes the opposite. Men in the U.S. can bring in sex trafficked girls from overseas, minor girls, under the guise of marriage, and it's perfectly legal. So the way it works, though, is that USCIS and the State Department are allowed to approve the petition of for a spousal or fiancé visa involving a minor only if the marriage would be legal in the state where the couple will reside. And that means that right now in New Hampshire, USCIS and the State Department can approve these petitions for minors as young as 16 and 17. Almost all of our neighboring states, in fact, every single one except for Maine, has addressed this problem by making the marriage age age 18, no exceptions, because that way USCIS and the State Department cannot approve these marriages. But here in New Hampshire, our girls are not being protected. And this is not a small problem, by the way. The U.S. Senate Homeland Security Committee issued a report in 2017 that showed that in the decade leading up to that report, there were almost 9,000 petitions for a spousal fiancé visa involving a minor as young as 13 that were approved by USCIS, and the younger party was a girl in 95% of those cases. Let's catch up to the rest of our neighbors and 11 states across the U.S. that have solved this problem by making the marriage age 18 no exceptions and stopping the legal trafficking of minors.
Any questions? Representative Nelson.
Hi, thank you, Mr. Chairman, and thank you for taking my question. I wanted to just get some clarification from you. So you're saying that even if we have, per RSA, age limitations and residency limitations here in New Hampshire, already in law, that the federal government can supersede that?
So what I'm saying is the federal government cannot supersede the minimum age, but it can follow the minimum age. And since the minimum age now is 16, that means minors at age 16 or 17 can be legally trafficked because USCIS can approve that. If we made the marriage age 18, the USCIS would not be able to approve the spousal or fiancé visas for minors as young as 16 and 17 who are being forced right now to marry adult men overseas, so they're being trafficked for their citizenship.
Can I please have a follow-up? I believe in current statute, both parties have to be New Hampshire residents.
My understanding is that one party needs to be a New Hampshire resident.
Oh, thank you.
Any other questions?
And Chair, I wonder if I could also address a question that was raised before regarding
Sure.
emancipation. So there was discussion, Representative Panic, I hope that my colleague Becca explained why the emancipation, that you're right, once you're married, you're emancipated. Unfortunately, those rights arrive too late to help somebody who is being forced to marry, something that we see almost every day at Unchained at Last, because these girls reach out to us and we have to say, well, nothing we can do until you're married. But beyond that, actually, the automatic emancipation upon marriage is extremely dangerous public policy. Because once a minor is married and emancipated, they lose their parents' financial obligation to them. And typically, before we emancipate a minor here in New Hampshire under the new emancipation statute, we first make them prove to a court that they are self-sufficient in their personal and financial affairs. But nobody is looking at that when we're emancipating minors just because one of their parents decided it was time for them to get married, because this can happen with just one parent's consent. In most cases, then, we're forcing these minors to become financially dependent on their spouse, which is a known risk factor for domestic violence. But it also creates another perverse incentive for a parent to force their own child to marry. What we're seeing is that parents are using this as a way to unilaterally terminate the parental rights of the other parent. One parent can marry off their 16 or 17-year-old without even notifying the other parent, and then the minor is emancipated, and there goes that child support obligation you never wanted to pay, or the child custody battle you want to get out of. And in fact, a case like this went up to the Idaho Supreme Court, where a woman found out her estranged husband had paid someone money to marry their 16-year-old daughter so he could get out of their child custody battle. And she lost when she fought it up to the Idaho Supreme Court. Supreme Court said, child is married, emancipated, nothing you can do.
Seeing nothing further, thank you for your testimony.
Thank you. Please vote yes on SB 359.
Now, just a little straw poll. We don't have to exec this bill unless we all want to. So is there anybody who thinks we should wait before we exec? Put your thumb up. Seeing no thumbs, that means we can go forward to exec this bill. So I close the hearing on Senate Bill 359, and I now open the exec session on Senate Bill 359. And the chair will entertain a motion. I'm ready to write. I will put all the letters down even though I don't say them, right?
Yes.
Yes, Levesque. Got it.
I move
And-
opt to pass.
ought to pass.
Second that.
And Petrino, Vascui, okay. Any discussion? I sensed on the part of a few folks a little bit of hesitancy, and that's okay. That's why we have the discussion. Representative DeSimone.
Thank you, Mr. Chairman. I took the time to look it up. On line 12, it says no magistrate or minister of religion shall solemnize the marriage. Doesn't say anything about justices of the peace, who in this state are not considered magistrates. And a justice of the peace can solemnize a marriage. So there's one issue that I have with the bill.
Could we look at just that when one would think that no justice of the peace may commit an act against an RSA, and if that person does so, that person would be subject to some strictures, and the act would be null and void.
Well, it doesn't say we can't do it. Doesn't say we can do it.
So, don't know. What's your pleasure? We can hold up for an amendment, or we can keep going and.
Because of the argument, we had offline discussions that the justice of the peace is bound by the RSAs. So if the RSA said you can't marry someone under the age of 18, you can't marry someone under the age of 18.
And if you think you're doing it, I think I'm a star for the Red Sox, so it doesn't matter. Yeah. Anyone else for discussion? Representative Bickford.
The issue of military was brought up. Thank you, Mr.
Yeah,
Chairman.
no, sorry, that was wrong. This is discussion. I just call on you.
Oh, okay. Anyway, military was brought up for an issue. And one of the things in the military, as I recall, they pay more if you have a wife or spouse, I should say. And so they've created a benefit that makes this advantageous to get married at a younger age. A lot of people go in the service at 18, 19 years old, and I'm going to say their girlfriend wants to be with them, or at least on base. And like I say, they get money for doing this. I know my daughter was not underage, but they get extra money for being married. I know it's not something I really believe in, because I believe in equal pay for equal work, but that's the way the system is right now. And so I'm hesitant to change because of that.
Representative Levesque.
Yeah, so I have researched this. I've talked to many of my friends who are military members. I've talked to my father, who's a military member. There is no room for a wife when it comes to basic training. When they enter into the military, there is no wife or spousal housing. They come with the trunk that they are given and the clothes on their back, and then they are introduced into basic training. Yes, they do have housing, but they follow a chain of command like the military does. Whoever is higher up in the chain of command, they get that housing first. And the military has realized that they realize that is an issue in that they're having with a lot of their members. And I'm not sure if there's been discussions of it. I know that I've talked to many military members who have said that that is an issue that they're trying to face right now, of military members, especially their younger boys, marrying off just to get benefits when in fact those, especially with the pregnant girls, the girls that are pregnant, they have found there's better ways to go about it than just marrying off just for benefits. I think and also if they find that they are marrying just for the benefits, then they will be court-martialed and handle the way that the military will handle it. They don't just let anybody get married just to get more money. They tend to have checks and balances in that military to prevent members just to receive more pay just from having a ring on their finger.
Vice Chairman Long.
Thank you, Mr. Chairman. Yeah, these discussions qualify why I believe that nobody should be married under the age of 18. I mean, we're having a discussion about a person going into service that may get another $20 a week if he's married. So we're gonna, so let's incentivize that underage marriage. So somebody entering the service could get extra $20 or whatever they get. I'm sure it's not very much. And then we have the discussion on, other discussions on nothing to do with marriage and the sanctity of it, but just an advantage. That's why I'm sticking with, if you're not 18 years old, you're not getting married.
Representative Raymond.
Thank you, Mr. Chairman. So just to kind of follow up on that, so what happens in the military is you get a one-time bump when you add a dependent. It is not when you get married, it's when you add a dependent. So that dependent could be a spouse, but it could also be a child. And it's interesting that we're having this discussion, and I'm reminded of one of the representatives who spoke, who pointed out that we allow only same-sex marriage starting at 18. So if you have a gay military member at 17 who has gotten permission from his parents to join the military, and they want to get married now so that they can have that spousal benefit, they're not allowed to. They're only allowed to do it if it's opposite sex, apparently. So to me, for the fraction of a percent of individuals who this might apply to, it's not a reason to put in danger all of the other individuals who are at risk of child trafficking. And again, the bump is a one-time thing when you add a dependent under their, I forget what it's called, it's their enrollment system. The acronym is DEERS, but I don't remember what all the letters stand for. But basically, it's adding your dependents to their system. And it's for base housing, basically, and your cost of living increase.
Representative Gifford. Representative Gabby Grossman. See, at least it's the same first letter.
Gets the first letter.
I know.
Thank you, Mr. Chairman.
Welcome.
Chairman P.
Been called worse.
Thank you. So this is my third term here, and this has been discussed since my first term with Representative Cassie Levesque bringing this forward for us. And I absolutely support this legislation. Going round and round, my head, we're putting kids at risk. We're putting young adults at risk. So whatever benefit may outweigh, whether it's a bump in pay or whatever it may be, the effect on our society when we have traumatized individuals that have experienced trauma and coercion, that's going to affect us down the road. The other piece that's always come up is this notion that a young person under 18 can't access help if they're in a domestic violence situation. That has continuously come up over and over, being turned away from support and help because they're a minor, not being able to get a lawyer. I remember our first term, it was, I don't think you could get a hotel room. You couldn't get a hotel room. So, but you could get married. So once again, here we are, and I'll be voting in support of raising the child age marriage to 18. Thank you.
The chair wishes to thank Gabby M. Grossman for her contribution. And now the chair recognizes Representative Greg.
Thank you, Mr. Chairman. I think, there's a lot of things when we look at this bill and between the House bill that we had this last year and then this bill, we're always looking at, what type of kiddo in this day and age is getting married that early. And we always go back to these abuse things. And I think there's another thing that we're kind of missing here. And I know that the New Hampshire way is we have our own little unique way of doing things, and that's usually pretty great. When we start to see all the states around us passing these marriage laws where we're going to 18, what does that make us? It doesn't make us the outlier who needs to play catch up. What it makes us is it makes us more attractive. Who is it making us more attractive to? It's making us more attractive to these traffickers. Yes, we've only had so many marriages in this last year, but let's look at it. We have a international problem of trafficking, especially with internet, especially with kids having their phones and being able to get online and meet up with people and stuff. We will make ourselves a very attractive state for child traffickers to come. So even though we haven't seen that yet, that's something to keep in mind when we are one of the only islands on this particular matter. So I will be voting for this for a million different reasons, but that's an added one. Thank you.
Representative Nelson.
I'm feeling ambivalent right now, one way or the other, but my concern is that we have such a larger problem with human trafficking, sex trafficking of minors, and raising the age of marriage to 18 is not going to solve that. And also in domestic violence situations of minors who are cohabitating. So I am hoping that my colleagues will join me, should we be reelected next time, to actually address the real problem that we have here. Thank you.
Well, my comment is, when I was young, I visited my family in rural Canada, a little town called Pearsonville, New Brunswick. And at 14, people were responsible. They did not have adolescence. You grew up quickly because the cow had to be milked, the absence of which is far more serious than you didn't take out the trash every other day. And I noticed my cousins in Canada were, because of this, much more mature. And so to get married at 15 and 16 was not a maturity problem. While that's not the people I see everywhere else I go, even in rural Canada. As a result, what might have been okay there 60 years ago, I do not believe is okay here now. And so I will be voting for this bill. Anyone else? Yes, Representative Ball.
Thank you, Chairman Pearson. I will admit that I voted against this bill last year. However, times have changed in a very short period of time. And I'm very concerned that a same-sex marriage is required to be 18, but we're not providing those same protections to the young women in our state. I will be voting for this.
Representative Perez.
Thank you, Mr. Chair, for allowing me to speak. As you know, last year I was very vocal about this bill, supporting raising that age to 18. As someone who, again, have life experience with, basically, I was only 15 years old, and my ex-husband, he was 47 years old. And someone who didn't know the language, someone who didn't know the rights. I had 11 years of trauma, pain, and struggles. And I don't wish anyone, because those scars, even though that I feel like I heal, they're gonna be there for the rest of my life. And I don't wish anyone, not even my worst enemy, to go through what I have experienced in 11 years of my life. So for that reason, I will support this bill.
Last call. The motion before us on Senate Bill 359 is ought to pass, moved by Representative Levesque, seconded by Representative Petrino. Would the clerk please call the roll?
Chairman Pearson,
Yes.
Vice Chairman Long.
Yes.
Representative DeSimone,
No.
Representative Bickford,
Yes.
Representative Nelson,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Melvin,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino will vote yes. Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Raymond.
Yes.
Motion carries 14-1.
Any objection, Representative DeSimone, to consent? No objection, it's on consent. And Representative Lebec, before you leave today, a nice little blurb for the clerk, please.
Congratulations.
This concludes the exec session on Senate Bill 359. I wanted to go way into the lunch hour because I wanted a lot of people who came here to see the disposition of this today. Now we're going to come back at 1:15. Okay?
Yeah, Peter, I got 15.
You know what? She's paying it forward and giving us her support.
Okay, let's go. Senate Bill 506. If you watch Downton Abbey and remember Carson, this is a different Carson introducing the bill.
Very much so. Good afternoon, Mr. Chairman and the honorable members of the House Children and Family Law Committee. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, which comprises the town of Auburn, Hudson, and Londonderry. And I have for your consideration this afternoon Senate Bill 506, which seeks to align other statutes with the Juvenile Delinquency Statute, RSA 169B, which provides that a delinquent includes anyone under 18 years of age. There's only 3 points to this bill. This is a technical cleanup bill. When the state raised the age of a juvenile from 17 to 18, a few spots in statute were missed, and this bill would clean up those remaining references to 17. And I'm concluding my testimony, Mr. Chair. And the attorneys that are here that requested the bill be filed will be more than happy to answer your questions.
Any questions for the senator? Seeing none, thank you so much.
Thank you, Mr. Chairman.
And the chair recognizes, I'm going to say, Attorney Stephen Andres. You know they're trying to get me to go to law school. I'm getting law books for Christmas now. So,
Well, I was going to say you had mentioned the Rules of Evidence book.
yeah, I read it 4 times with the footnotes.
I think that book costs over $200, the little tiny skinny one.
Yeah.
Yeah. Anyway,
The chief gave me a copy, and I know it's going to be on the test, so
It's an
I read it
expensive
4 times. It really is.
my name is Stephen Enders. I'm an assistant county attorney at the Merrimack County Attorney's Office. I've been a prosecutor for over 20 years now. Just to not reiterate what Senator Carson said, but essentially this bill in 2017, the age for entry into the criminal justice system was raised from 17 to 18 years old. And there were a number of statutes that were sort of lagging behind that didn't get changed. This goes back, looks at those statutes, and changes the age to 18 so that everything is aligned now and unified. I'm happy to answer any questions. I was going to say, there was also a handout that
The handout is
came
being
with me
passed around.
that has everyone who supports it written in it.
Wow.
Thank you.
Any questions for council? Seeing none, thank you very much. No other pink cards. So therefore, I conclude the hearing on Senate Bill 506 FN. And what do you think? Yeah? Yeah, the last time I testified and said, this is a housekeeping thing, 2 hours later, it was turned into something totally different. It was a significant improvement. Thank you, Lucy Weber. But I don't use those words anymore. But this, I think, qualifies. All right, then I will open the executive session on Senate Bill 506. And who would like to make a motion? This gives you the honor of writing the blurb. Representative Ball. You cannot withdraw that. So who can second? Oh, it's Greg. Yeah, Representative Greg. Any discussion? Middle initial M. Molita? Malia, wow. Yeah, yeah. Any further discussion? I've learned Representative Grossman's middle name during this break. Anything else? All right, we have a motion before us on Senate Bill 506 FN. The motion is to pass by Representative Ball, seconded by Representative Gregg. Would the clerk please call the roll?
Chairman Pearson.
Yes.
Vice Chairman Long.
Yes.
Representative DeSimone is not present at the moment. Representative Bickford.
Yes.
Representative Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic,
Yes.
Representative Melvin. Yes. Representative Grossman.
Yes.
Representative Levesque is not present. Representative Petrina will vote yes. Representative Perez.
Yes.
Representative Gregg.
Yes.
Representative Raymond.
Yes.
Motion carries 13-0.
Any objection to consent? Seeing none, on to consent it goes. This concludes the exec session on Senate Bill 506, and now open the hearing on Senate Bill 498, relative to DCYF. And in today's exciting episode, the part of, what? You're not coming back till 1:30?
3 more minutes.
We have 3 more minutes.
According to which clock? But it's Tuesday, not Wednesday, right?
Oh.
Thank you. Oh. She came to our Halloween day as Wednesday Addams. She rocked it. It was really good. And she was very polite and didn't refer to me as Cousin It.
Me as Uncle Fester.
Uncle Fester, yes, I can. Uh-huh.
Now you got it.
Ooh, thank you. Got it. Appreciate it. Yeah, folks, if you're interested in going on either or both of those committees we put together this morning, just send me a note. Thank you, Representative Perez. That, by the way, is the final countdown. I played that before a wedding once. They had been engaged for like 8 years, and I was the organist that wedding, and they were goofballs, both of them, and I figured, what the heck? And so I did my nice 20-minute concert, and they were late, and when the bride finally came around the corner, I gave a rousing chorus of the final countdown, and they liked that much more than Wagner, which was the wedding march. Yeah. Okay, do I have a card? Introduce, oh, I'm going to do that, aren't I? That's this. Ms. Dyer, may I? Open the hearing on Senate Bill 498 FN relative to the Department of Health, Human Services Division for Children, Youth, and Families. In today's exciting episode, the part of Senator Bradley is being played by the chair. So I am introducing this bill, and I have some all-star cast of people ready to speak to it and some written documents. So the chair recognizes Attorney Susan Larrabee.
Good afternoon, Chairman Pearson and members of the Children and Family Law Committee. My name is Susan Larrabee. I am General Counsel and Chief of Legislative Affairs for DCYF. Good afternoon. This is a DHHS requested bill, and I'm here to provide information for you and to go over the bill, Senate Bill 498. Basically, Senate Bill 498 in the first section aligns and adds language to the juvenile justice delinquency section of 169B, which is on page 1, sections 1 through 4, which would be lines 1 through 30. As well as 169D, which is Children in Need of Services, which begins on page 2, and that's line 15, continuing onto page 3 through line 13. Basically, what the added language aligns with the Child Protection Act of 169C, pertaining to the placement options for children that is consistent with federal law, the Family First Prevention Services Act of 2017, which allows for not just relative caregivers, but kinship caregivers to be a placement option for children, not just with CPA, with the Child Protection Act, but for children involved with the juvenile justice system in both the Delinquency and CHINS Act. And that language of adding kinship would be aligning with that, with both federal and state law, as well as adding the placement options of certified residential or psychiatric placements. That is also part of the Children Protection Act. Secondly, on page 2, section 5, which is lines 1 through 14, we'll be amending the reporting dates of the Youth Detention Center logs. Those reports go to the Department of Health and Human Services biannually. And the way it's stated in the statute now, the dates of reporting are January 1st and July 1st. We request that the bill be amended as the language states in Senate Bill 498 to align itself with the federal reporting dates of the Juvenile Justice Delinquency Prevention Act, which would change the dates of reporting to October 1st and April 1st. And lastly, this bill on page 3, which is section 10 of the bill, lines 14 through 19. This bill would repeal the prospective repeal of the section known as the rebuttable presumption of harm that went into effect in 2021 with House Bill 1162 that had a sunset provision of July 1st of this year, of 2024. So this bill would be repealing the repeal of that sunset provision. We have asked for that because we find that the rebuttable presumption of harm is a very important evidentiary tool. It is trauma-informed with all that we know about early childhood adverse effects. It does not change the definition of neglect. That's why it's an evidentiary tool under 169C12. The definition of neglect remains the same. It's a two-prong definition in which a child is a neglected child who is without proper care necessary for the child's physical, mental, or emotional well-being. And then that second prong is that when it is established that a child has suffered serious impairment or is likely to suffer serious impairment. I know it's a mouthful, and there's many elements involved with what factors the court is to consider when looking at serious impairment. And the Supreme Court has simplified it to be harm to a child or potential harm to a child. And that's the hard part sometimes in court, because that's not in line with what we know about early childhood adverse effects, and that harm occurred, but it may not immediately manifest itself. It may not be readily apparent to a child who has been exposed to certain situations and experiences in their home. And therefore, that would prevent sometimes the state from acting, from intervening, or delay intervention, waiting for that harm to manifest itself. And that's not in line with what we all as a society know about early childhood adverse effects. And therefore, 4 years ago, it's my understanding that the legislature heard testimony from many entities, including a review of the federal review of cases that were not acted upon, and saw that consistently those were the ones that were considered to be exposure cases, when children were exposed to certain conditions in the home. And those conditions put them at risk of serious impairment. So therefore, House Bill 1162, which did a lot of great things for child welfare, it finally defined psychological maltreatment. It finally included a step-parent as a parent of a child. And it included 4 rebuttable presumptions of harm, in which the court may make a finding that a child has been harmed a rebuttable presumption that this child has been harmed unless and until proven otherwise to certain exposure cases. And that is when a child is exposed to substance misuse in the home that is adversely affecting the care of the child. When a child is exposed to driving while intoxicated by being in the car with a parent who is driving while impaired. 3, when a child is exposed to physical violence in the home by the parent. The parent is either physically violent towards another child in the home or another adult in the home, and that child is exposed to that. And lastly, when a child is exposed to psychological maltreatment, either they themselves are the victim of psychological maltreatment or they are exposed to psychological maltreatment in the home to another adult or another child in the home. And that is a very important evidentiary tool that we hope with the passage of this bill, that you pass this bill to repeal the repeal of those rebuttable presumptions of harm. And I would be happy to answer any questions about the bill.
Under those 4, 3 of them are very discrete situations. But I question about psychological maltreatment. How broadly could that be taken? For example, the child really wants something, and the parents, for whatever reason, do not believe that the child should have that. We're talking major things. Would that be considered psychological maltreatment? And the child could say, I wanted to have tattoos and my parents forbade me, and because of that I am suffering. To me, psychological maltreatment could be runaway.
If I may, with House Bill 1162, the definition of psychological maltreatment was added to the definition section of 169C3. And if you could give me a moment, I believe I did bring the actual statute with me.
Well, if you didn't, we got them all over there.
Perfect. I can go. So before I joined DCYF as a general counsel, I worked for UNH and I was a trainer. And after 1162 was passed, it included the provision that all DCYF and other stakeholders be trained on House Bill 1162. And I was actually a trainer of that. So I will refer to my previous notes on the trainings that were some years ago. So I'm a little rusty with that definition. It defines the law, the statute of 1162 added to the definition of psychological maltreatment and was added into the law of pervasive and emotionally abusive behavior, which shall include, but not be limited to, patterns of threatening, berating, or demeaning behavior. So it's a course of conduct of behavior that is threatening, berating, or demeaning.
Parents being parents and saying, no, you cannot do that, would not fall under any of those unless the language used. And so it becomes a berating language or physical threatening language.
Correct. Because as we know, emotional abuse and words have sometimes a lot more effects on a child than...
Oh, sure. But sometimes saying no, a child can perceive that.
Of course.
But
And that's why I think you all, if anyone was present during the House Bill 1162, took all of that in consideration and talked about pervasive and emotionally abusive behavior.
Yeah, I was a co-sponsor to that, so I just want to make sure I didn't, open up something. Representative DeSimone.
Thank you, Mr. Chairman, and thank you for taking my question. So when I raised my children, I had a sign on the refrigerator that I replaced frequently because I had to get the jelly stains off. And it said, sticks and stones can break your bones, but words can break your heart. And I always said to the children, be careful how you speak to somebody. So I found it difficult for myself when I reported somebody for calling their child an effing moronic idiot. And when I reported it as abuse, I was told, sorry. So it seems like this bill, am I correct that this bill will make a corrective action in that aspect? When you're constantly verbally berating and telling a child that they are not what you are telling them they are?
Exactly, because it's patterns of threatening, berating, or demeaning behavior. So in the court of law, that'd be very hard to prove that a child has been harmed without this rebuttable presumption of harm.
About time, thank you.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my call. Do you have any idea why, what was the, sorry, I'm just like wondering, it's baffling. What was the reason for the repeal of that?
That's a good question. I don't know actually the origin of why it has sunset provision in it. I know that these rebuttable presumption of harms, the 4 of them replaced the opioid rebuttable presumption that had a sunset. So I don't know if that's why it was replacing another provision that did sunset. But other than that, I would be only guessing.
Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question. I actually wanted to just go back to the first and second parts of the bills. Can you just explain fictive kin and what that legal definition is for us? Just because it's something new since I worked at DCYF years ago.
I can. Fictive kin is defined in 170E25, Roman numeral 8, in which kin means a child or children who for which there is a connection or history between a child or their parents and another responsible adult, including but not limited to a relative or related adult. So it's someone known to the child. It can be a relative, but it doesn't have to be a relative. It can be a coach, it can be a teacher, it can be a neighbor.
Thank you. I think that's great. Right?
Yes, Representative Ball.
Thank you, Chairman Pearson. Thank you for your time and coming to answer our questions. There's something about this that's just not sitting right with me at the current moment, because you're saying threatening, berating, and demeaning, which are all very subjective, which means we're placing our values on another family without even the evidence that there is harm being done. I understand that over the long run, children, we all have stories about what our parents might have done to us. But I'm concerned, and I'm just wondering, how does this fit when you talk about psychological maltreatment? Where does parents that have diagnosed mental illness of maybe borderline personality or bipolar disorder, is this going to unfairly impact them because that's how they could tend to treat their children, with a lot of threatening behavior or berating, or especially with 1 minute they're happy-go-lucky parents and the next minute they're screaming at their children? So I'm just wondering, how is this going to affect our community that is diagnosed, and is that going to stop people from getting help for their mental health issues?
Thank you for the question. Well, first of all, it's twofold. The rebuttable presumption of harm is applying psychological maltreatment. That definition is defined in the definition section of 169C3, and that is not part of the repeal. The repeal is the rebuttable presumption of harm. And again, it's a rebuttable presumption. It's not an irrebuttable presumption of harm. Right. So if there's testimony that the parent was repeatedly calling a child a derogatory name in terms of calling them obese and what that means to be calling them obese, and did certain actions because they called them obese, or did other forms of emotional abuse, that's a rebuttable presumption. It's not irrebuttable unless proven otherwise. It just makes it easier to prove harm, but it's not saying it is harm in and of itself.
Follow up? Follow up. So just to make sure I'm getting this clear. So I understand that it's rebuttable, but it's also presenting an opportunity for parents to go after each other in making claims against the other parent for what they would perceive as mistreatment or I guess I'm worried about the subjectiveness of it, especially when it's something that you're not seeing. It's just something maybe I wouldn't particularly raise my children doing it one way. So I'm trying to understand and square this whole thing is how do you prove it, but also how do you disprove an allegation?
Well, I think you have to also start with the foundation of that all evidence in court has to be material, reliable, and found to be credible for it to be found to even apply the rebuttable presumption of harm. So typically, say, for instance, if there's a child who goes to the Child Advocacy Center and has a forensic interview in which the child describes acts of the parent that is emotionally abusive and berating, and that is evidence, that's material evidence, it's reliable evidence, it's credible evidence that the state would put into evidence during an abuse and neglect action for psychological maltreatment, and that evidence is weighed by the judge. So it doesn't change, like I said before, it doesn't change the evidence of putting in reliable, credible evidence. It's just that once that evidence is ruled to be reliable and credible, admissible evidence, then the judge weighs that with the evidentiary tool of a rebuttable presumption of harm.
The chair welcomes Attorney John Williams to where he is now seated.
And thank you very much, Chairman. For the record, my name is John Williams. I'm the Legislative Director for Health and Human Services. And just here to complement the testimony that's being provided to you, very astute testimony from Attorney Larrabee. I actually was involved with the underlying bill, working with many of you on the committee that dealt with the rebuttable presumption around harm. What I wanted to clarify, particularly for you, Representative Ball, that is actually currently in law today. And the reason the sunset provision was placed into the bill was primarily at the request of the pediatricians from Dartmouth and other areas, because they were concerned about the perhaps chilling effect that would have in terms of reporting in cases where a parent might have a substance use matter. And so we have worked with them very collaboratively. You heard from Attorney Larrabee about the training that we've done for the interpretation to making sure that we're very sensitive, because we want people to address their substance use issues, and also we want to make sure that kids are safe. And I think we've done a really good job balancing the whole perspective of the current law. Now, the sunset was put in here specifically for this to be road tested. And I'm not saying because you don't hear clamors of hundreds of people behind us that that is evidence, because that's kind of lack of evidence, but it is an occasion where this has been road tested and gone through the process. And that's why we're here today to request this committee to remove the sunset provision. Again, the issues that you're discussing are in current law. This is nothing new that this bill is trying to do. It's just eliminating the sunset provision in the law because it is working and it is protecting kids. And if it isn't working in the future, you will certainly have folks coming before you seeking other changes of the law, but we're not trying to change it all. And I'll repeat, we're not trying to change at all the current provisions of the law as it relates to the rebuttable proof of harm. So, Attorney Larrabee, anything?
I have a question. Some of you may remember House Bill 1573, which was about outplacement of children who needed to be placed somewhere. And there were hours upon hours upon hours of work that went into that by the Office of the Child Advocate and Department of Health and Human Services, and one poor legislator who really wonders, please tell me, that this 498 is in a different place. It is not dealing with 1573 or its Senate cousin. I think it's 417. This is something different.
Correct.
Thank you.
Yeah, and I don't say the same word, Chairman, that you also say about certain types of bills, and I probably met a couple of your folks returning from lunch that I did this. This truly is one of those bills that we're coming back. Again, the frict of kin, very helpful pieces around Family First, putting that into legislation, changing the date for reporting for detention from January 1st to October, are the periods that we had under the federal, and then finally just seeking not any change to current law as it relates to rebuttal proof of harm, but just addressing the sunset provision. If you do nothing here today, what will end up happening is that it is scheduled to sunset on June 30th of this year. And so that's why we're here very thoughtfully to saying it's working, it's been road tested, and if there's any other changes needed, people will come to you. Our only goal here is to address the sunset provision.
Anything further? Thank you, Counselor, and thank you, Counselor.
Thank you all.
Thank you.
This now ends the hearing on Senate Bill 498, and we're done. We're done. Where was the card? That's not the point. The question is, we usually have the cards. Do you have something you want to say? Okay. I'm a softie. Chair recognizes Vice Chair Erica Leon from Health and Human Service Elderly Affairs Committee.
Thank you, Mr. Chairman. I apologize for not passing that up sooner. I remember you calling many last calls for cards in the
I'm
past.
sorry for being grumpy.
I'm Representative Erica Leon. I represent the town of Derry. I come to speak to you about my concern about one particular phrase that is included in here, fictive kin. My concern around that is, as I was looking through the statutes, I know it was referenced, but I did not find it in our existing statutes. And I also am just quite concerned about the possibility of placing children with somebody who may have an inappropriate relationship with them and may be in a position of authority. My mother was a public school teacher, and the only way that they found out that there was a teacher who had decades of inappropriate relationships with children was after the teacher's lounge was vandalized in a horrific way, because the same thing had happened to one boy's brother that had happened to him. Until that day, that teacher was well loved and well respected, but they found out that there had been a pattern of abuse over decades. My concern is simply around the fictive kin. I recognize the need to make sure that there are people who are important to a child who are involved. When I first heard about this, I asked, what's fictive kin? Oh, that must be Uncle Mike, my husband's best friend from growing up, who is the one who will be raising our children should something happen to us. And we have that in documentation. I know not everybody else does. But my caution here is that there are people who are involved in children's lives. There's one from my town who had been an assistant at a school, and she has another parole hearing coming up. She had an inappropriate relationship with one of the students. What if he had been placed in that house? The horrors that had happened there would have been even worse. So I just some caution on expanding the ease of placement in fictive kin, because, I'd say probably 9,999 out of 10,000 people who would be in that situation are good, but we need to be sure that that balance of power and the potential for an inappropriate relationship with somebody in a position of power isn't something that moves a child from the frying pan into the fire.
Any questions for Vice Chair Leon? Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. Do you believe that there are also people who are relatives and guardians who also are abusers, and it's already in law that they would be able to be responsible for this child's care?
Yes, and that was one of the challenges and tragedies that faces, especially this committee, dealing with those difficulties, because you need to treat everybody fairly, and sometimes there's bad people that are able to disguise how they act, and it's the challenge. If this was easy, all these kids would be safe, and I commend you guys for everything you do in order to protect children.
Follow up, please.
Follow up.
So with that being said, I think it's logical that we would have to treat everybody in the that's presently in statute and also fictive kin in the same way in order to vet them equally, because we would have to view all of them as, potentially either very good equally or harmfully potentially. So how would you, what would be the difference in vetting those two types of people?
Well, thank you for that question. I recognize the vetting process is challenging. It's something that actually is probably worth some evaluation and to see what that vetting process is and to make sure that in certain situations it's not fast tracked just because of a good feeling about somebody. That's something that I promise I'll look into and see if there's something that can be done in terms of that. However, the more that we open this up to additional people, the more opportunities for problems there are. Yet I also understand we don't want to be putting children into homes. We don't want to be shipping them out of state. We don't want to be putting them somewhere else. But we need to acknowledge the fact that there can be inappropriate relationships.
Representative Raymond.
Thank you, Mr. Chairman. My question is actually for you, Mr. Chairman. Can we ask DCYF or the representatives from DHHS what the vetting process is for placement with people who aren't certified foster homes or certified placement?
Representative, I was just about to do that.
Oh, thank you.
So thank you for seconding that.
Because I think the representative makes a good point.
Thank you. If you're done with me, I'll step away from here.
Anything
Thank you for
else
hearing me.
for Vice Chair Leon? Nothing. Thank you.
Thank
Okay.
you.
Now, how about Representative Raymond's question? You're it, guys. You too. You represent all 4,800 DHHS employees.
Well, thank you. So back in 2022, kinship care homes were added to the definition of foster care facilities. Kinship care home means a type of foster home in which an individual or individuals are licensed to provide care exclusively to kin. And then, like I said before, kin is defined, as I read that definition earlier. There shall be a maximum of 6 children in the home, and children receive for child care who are related to the residents, those 6 other people. We are currently in a contract with an organization called a Second Chance. They are the ones that are licensing these kinship care homes. So once they are licensed, they are able to receive foster care payments, because that was the hurdle, that many relatives and fictive kin were being vetted but were unable to receive foster care payments and maintenance for the care of these children. So based on the changes to the statute in 2022, these kinship homes are being licensed and will continue to be licensed. And during that licensing process, there's obviously an application of vetting, a home study, background checks, and all that goes into making sure that the child is placed in a safe and appropriate home that is with someone they know.
Follow up.
Thank you, Mr. Chairman. So what happens when there's an emergency, or even in this case where a delinquency has happened and a child needs placement? Do they have to go to a group home while the Uncle Mike or whomever is being vetted through the vetting process, or can they go there like on a conditional basis while the
My understanding is, I'm not the subject matter expert at this, but this is my understanding working on the licensing process with kinship care homes, is that there are certain things that are called day one, non-negotiables, that have to be done that day one in order to place child with the uncle, and that uncle has to have a background check, which would require the CPSW to call the local PDs to come in, observe the home, do a walkthrough of the home, and ask and be answered certain non-negotiable questions regarding safety of that child. And then after that, the more formal vetting goes in terms of the FBI fingerprinting, the background checks, the central registry for abuse and neglect, the sex offender registry, and other processes of vetting that individual. Thank you.
Okay. Oh, and one more pink card. Chair recognizes the Honorable Betty Gay, an emerita representative.
This isn't written down. Betty Gay from Salem. And I'm going to try to give an example of what Representative Nelson referred to. I had never heard of fictive kin until January, when a person who I can't name them because it does involve a child, but a person that you've heard many times, so you'd have respect for, had a child, 15-year-old, knock on her door and ask if she could have a drink of water. She'd been walking a long time. Turns out everybody at school and the police knew this child's situation. The person abusing her was her aunt's husband. So she could have been there, but thank goodness for fictive kin. This person whose home she just decided to walk up to because it looked like a place people came to. They had a sign out front. This child, the school knew the situation, and the police actually had her real aunt say to them that very day, I don't want her. And because it's just like it was preordained, it was supposed to happen. This child is now under their care. It was established immediately because of the fictive kin, permission. I'm not sure what word to use, but because it is allowed, this child could once again go into a home and be cared for while they were doing all the steps necessary. Because if they had waited for them to complete the foster care, that would have taken a few months. Meanwhile, this child needed shelter immediately. And so the story, that's how I found out about it, because I was called, would you be a reference, a personal reference for the new fictive parents? So I thought I had to say this because, as Representative Nelson pointed out, you don't want to send a child anywhere where they're not going to be cared for safely. But you can't just assume that because they are relatives that it's any safer than someone that you're vetting and have a relationship with. So I certainly support continuing the fictive relationship, qualifying people to be caretakers of children who need a safe home.
Any questions for the retired representative? Thank you.
Thank you.
We all knew what this was. It was that nice person down the road that was, gosh, he's more close to me than my biological aunt and uncle are. We just didn't know what the term is. So I think we've all had knowledge of fictive, except for the title. Well, what do you think, folks? Ready to go ahead on this one, too? All right. Yes, Representative Raymond, was that hand?
No, I meant it to be a thumbs up.
Oh, that was more than one thumb. Okay. All right. Who would like to move OTP and write the blurb? Oh, this ends the hearing on SB 498, and this opens the exec session on it as well. Who would like to move OTP? Form one line.
I'll make the motion if I
Thank
can have
you.
the sheet.
And the motion is?
The motion is OTP on 498, please.
Thank you. And who was that? Representative DeSimone? Okay, and let's roll on this one because she's got to leave.
Yep.
498, relative to DCYF, moved by Representative Raymond, seconded by Representative DeSimone. Clerk, please call the roll.
Chairman Pearson.
Yes.
Vice Chairman Long.
Yes.
Representative DeSimone.
Yes.
Representative Bickford. Not here at the moment. Representative Nelson.
Nelson.
Yes.
Representative McMahon.
Yes.
Representative Ball. Representative Panic.
Yes.
Representative Melvin. Yes. Representative Grossman.
Yes.
Representative Levesque is not present. Representative Petrino will vote yes. Representative Perez.
Yeah.
Representative Gregg? Representative Raymond?
Yes.
That would be 13 to
10
0.
to 0. Consent? Yes, good. Thank you. This ends the exec session on SB 498. It also ends our day. And once again, on the first two bills we saw that were establishing committees, if you would like to be on one or both of them, please either email me or give me a note accordingly. And there we are.
John, hey, on second chance, do they vet household members also? Do they vet household members? Do they vet on second chance? Do they vet household members also?
Yes.
Okay, so
Yes. If they want, in
So
order
they-
for that relative to get foster care payment, they have to be licensed in order to get that. I mean, in order to get that,